My lord,
And one more,
What is the check amount?
well, check 30 lakhs. And that time, that amending act had not come, that 20% deposit.
143 and
140 had not come. So there is no deposit till date.
my lord,
And item number 6 of the hearing list, if can be taken up before
We'll see
rising.
how- Let us. see.
After your lordship.
Yes.
my lord, item number 146.
Hmm.
My lord, it's a criminal appeal, my lord. The vigilance, criminal appeal, 146, my lord.
1 minute, 140. Yes.
Here the vigilance council have, your lordship, in that case, your lordship, it is a trap case, your lordship. And it is a matter.
Now,
in
what do
the-
you want?
Well, I want that it may be taken up in the, it may be
The
listed at the
problem
top
is
of the list.
when there was the opportunity to argue, you people didn't, you avoided the court. I had to abandon the court by 2:30, 3 o'clock like that. And now you see the pressure, what to do? We'll see. I'll give priority if you are ready. The other side has also to be ready, na? Down the line, if that is there, they are ready in a couple of matters. Nobody came forward. So that's the whole difficulty. Let us see.
My lord.
And you just intimate the
Well,
other side who is appearing.
I'll intimate.
Mr. Maharana is appearing. Who is appearing for the other side? Just
Mr. Maharana, I think, appearing.
tell him that he should be also ready so that I'll take it up. No problem.
My lord, hold on.
Lords, I may be pardoned, 127.
Yes.
127, there is 3 appeals. Last occasion, Lordship directed to 2 PM, maybe 3 appeals and I am.
Last
like-
occasion is
let's say 2
different
PM
and
maybe.
today the occasion is different. That time I was thinking at keeping it 3 o'clock I can finish it up. But I don't know whether miscellaneous matters can be finished by 3 o'clock.
2 PM.
We'll see.
Pardon to make a mention. CRMC number 3001 of 2019 matter. The pleading in this case has been completed. And yet the trial has not been commented.
You challenge what? You decide. First you decide what you are challenging. Then you mention it. Okay.
I may pardon, my lord, item 16 may be taken up.
16. It will be taken up. Will come.
Pardon to mention, my lord.
16 will be taken up obviously with serial. Huh?
Starting from 20.
Well, matters.
Then what is the 16 is about?
13(1) PCR.
Huh?
Vigilance case.
Vigilance.
Appeal hearing. Miscellaneous hearing has to be done. We'll see. We'll see after miscellaneous matter. I'll try to take up. Who is appearing for the other side?
Vigilance case.
No, who is the lawyer?
Rijvi, Mr. Rijvi.
Rijvi, let the Rijvi come. We'll see. First miscellaneous matter. I can't start hearing a appeal in the morning. Giving bail matters and all.
A date may be fixed, so that can be.
Date is there. It will be remaining there. You get ready, come and when Mr. Rijvi is there, I'll take it up. Don't worry. Yes.
Pardon to mention, my lord. To adjourn bail matter, my lord.
Bail matter will come in serious.
Serial issue.
One is CRLM, my lord. Pardon to
Everything will come in serial. I am not going to entertain it. Because
the
otherwise
modification of order.
Huh?
Modification of order. CRLM.
Modification. What modification?
One IA had not yet disposed, my lord. 3 number of IA has been filed.
Also, you take it, small matter.
Yes, ma'am.
Pardon to mention, my lord, previous week listed was criminal revision 632 of 2012 as not listed this week.
It will listed, give it.
I beg pardon, my lord.
Yes.
On Thursday, last Thursday, I had made a mention, criminal miscase number 2498 of 2016, my lord. My lord, your lordship directed the matter to be listed today, my lord.
What
It
was
has
that
not
matter?
come. That is a matter, my lord, where I have challenged the cognizance order taken under section 138 NI Act, my lord. My lord, the interesting case is, my lord, the check has been presented before the date of the check. And the court below has taken cognizance. That is
What
my
is the check
challenge.
amount?
Check amount is something around 2-3 lakhs. Exactly, I have not remembered. But
Then now, after presentation, the date has come. You had issued the check. Come with the money, you pay.
no, my lord, it's a fraudulent my lord,
Have you-
presentation of check,
Have
my
you
lord.
registered any case
Because-
that your check is misplaced or-
Because they had taken a security check, my lord. Or whatever be it, my lord. The statute is very clear that it must be presented after
forget,
the.
you have given the check, you have to pay it money and insolvent, everything we will fix and pay it and finish it up.
No,
Least it we will see. Let the other side come. We'll settle it, try to settle it.
Settle ହେଇପାରିବନି ସେ company ବି ଆଉ ନାହିଁ
Let us,
company ବି ଆଉ ନାହିଁ
yes. Item, we see there is, any mentioning in the VC?
item 74 million permitted to withdraw I have filed memo
74 withdraw,
item
74 withdraw, huh? Yes.
132 million the vigilance matter last week also mentioned my lord
You, now you see the board what to do.
kindly taken off my lord.
No, let it be there. I'll take it up. Don't worry. I'll take it up. Whenever I get time, I will. Put it. Okay. Next. Any mentioning?
Item 26, Milos. Item
Yes.
26.
Yes.
1 week after, Milos.
Let it be there. Let us see whether we are reaching there or not.
I'm
26. Yes.
Well, item 25, may I
mentioning?
make a mention, my lord? Item 25.
Yes, yes.
Well, in item 25, there are two items, my lord. The first item is of mine, my lord.
Yes.
5128 of 2023.
What do you want? You tell me.
My lord, I want to withdraw as per the instruction from the client, the first item, my lord.
5128. 5128. Withdraw. Huh? Learned counsel for the Mr. Biswajit Ranjan Tripathi. Biswajit Ranjan Tripathi, learned counsel for the petitioner. Seeks to withdraw his petition. Can't see that. May you file the memo.
My lord, in course of the day, I am fine. My lord, in course of the day, I am obliged, my lord.
First item. That is 5128. Withdraw. Yes. No, nothing. Item 20. 20. It
May I
is start from
please?
20? Yes.
May I please, your lord?
Yes.
This is that case, my lord, where, my lord, your lordship will find, my lord, FIR was lost. Lord, I am just placing the facts in brief, my lord.
Hey, what do you want in this case?
My lord,
What thing?
quashing of the charge under section 302, my lord.
302?
2.
Yes.
My lord, here, if your lordship will kindly turn to annexure 1, my lord. The first information report, your lordship will find this was registered under sections
Oh, I saw it. Yes.
498, 304B, 302, 34,
Yes.
4 of the Dowry Prohibition Act, my lord. Now, my lord, investigation was
Yes.
conducted.
Filed.
Charge sheet has been filed. Your lordship will kindly turn to,
I
Page-
saw that. I saw that. 18.
yes, My lord, charge
304P
sheet-
and 306.
306, my lord. Now, on the basis of this, my lord, the charge has to be framed, my lord. I filed an application for discharge. Discharge petition was
Not
rejected.
necessary.
My lord,
This is not necessary. From the charge sheet, if the court finds some other
No,
offense is also made out.
my lord,
Do it.
that I will satisfy your lordship. That I am satisfied, I will satisfy your lordship or basing on the,
That too allied offense. It is
Basic-
302 or 304B or 306.
no, 306, if 306 is there, your lordship will find charge, your lordship will find last annexure.
Yes.
The court below has framed charge under section
Order is 34. Yes.
306 with 302, my lord.
306.
6 with 302 and other offences, my lord.
The earth is not conviction, sir.
My lord,
Ultimately, the court after.
no, my
That's
lord,
an
that is, I have got the
ultra-delicate-
answer. Take care, won't you? I have got the answer on the basis of the decision of the, my lord, Honorable Apex Court, as well as the Honorable High Court of Rajasthan, my lord. Yes, I will show to your lordship, my lord. Now, your lordship has seen, my lord, because why I say this, my lord, the courts have, the Honorable Apex Court as well as the Honorable High Court of Rajasthan, they have discussed these things, my lord. They have come to a conclusion that 302 and 306 diametrically stand.
And you need not labor on that. So,
My lord, I am showing this, my lord.
I understand.
Your lordship will.
But those things must be after conviction, all these things might have happened. Not on the charge sheet.
My lord, your lordship will
Mr.
find.
Mitra, do you need to labor on this issue?
Yes, my lord.
You know that.
Because
You are
302.
trying here and there, but you know.
Because there is absolutely no, because why I say, my lord, I'll show to
We
your
will
lordship.
not waste time.
I'm just, my lord, relying, of
After
course.
conviction, after the
My lord,
conviction, it
the-
might have happened.
Honorable Apex
Charge
Court
says
decision.
charge can be framed and the evidence on the basis of evidence, after the prosecution evidence, court may come to the conclusion it may be 302.
Yes, my lord,
or
but
306.
what is the stage, my lord? What is the stage that has to be
Whether
seen, my
charge
lord?
stage-
Because your lordship will
charge
find,
stage whether legally
No.
permissible or not.
because the very thing is, my lord, I will be prejudiced there, my lord. Because if your lordship will kindly consider one thing, my
Show me
lord.
the judgment.
Yes, I am showing, my lord.
Show me the judge.
Yes. My lord, this is the decision of the Honorable Apex Court.
So
Your lordship will find.
you have directly covered, we can think of.
Your lordship will find page 10, your lordship may kindly come. Those.
First paragraph read.
No, first paragraph.
First paragraph read.
First, your lordship, I am taking your lordship's kind attention to paragraph 10. No, my lord, page 10.
Yes,
Your lordship will find.
right. Also in the
the
given
third-
case,
No,
it will be doubtful whether the appellant can now be convicted under section 306
IPC
As
as
we
we
prima
prime
facie, I
facie.
find that the charges under 302 and 306 is antithesis to each other. That's the law.
Yes.
Then why should you
So,
bother?
so my lord, what I.
If you are convicted under 302 and 306 as well, then come to this court. I'll pass both.
No, my lord, my lord, what happens, my lord? 302, because my lord, the ingredient of 302, very 302, your lordship, if your lordship will kindly consider, it's a homicidal death, my lord. The ingredient is there must be a homicidal death. Whereas 306 is a case where it is a suicidal death, my lord. My lord, if the prosecution has to make their stand clear that whether they want to proceed saying that it is a homicidal death or it is a suicidal death, my lord.
Will you take the liberty to argue all these points before the trial court at appropriate stage, or simply withdraw it? You come to see the
My
best
lord,
part is
what
this,
happens?
that side-
Perhaps,
See, Mr.
perhaps
Mishra, I'll tell you.
in my lifetime, I have never seen such a case where the charge has been framed. Because your
No,
lordship,
don't say that. Don't say
why I say, my lord, why I say I am
You
supported
have
by
first
law, my lord.
experience in-
If your lordship will kindly refer to section 216, my lord.
I read it all.
There is a provision that if subsequently evidence comes, the court can alter the charge also.
What about
My lord,
464 of
Or
CRPC?
464 is, my lord, where the higher offense is there, lower offense it can be, the court can
Also be
convict.
there, including
My lord,
that.
my lord, but
304, 302, everything can be go together as a charge.
306 and
And
302,
when
how
at
they?
at the end, when the
Because-
conviction takes place, then on the basis of.
Because another angle, if your lordship will kindly consider, am I not being prejudiced, my lord, by this way? Why I am saying, my lord, I have a statutory right to challenge the, my lord, to file an application for discharge, my
I'll
lord.
tell you, listen to me. The best part, that side and this side is, when you know you don't have a case, till you argue. But sitting this side, if you know that there is no,
No,
you have to dismiss him.
If there is a point, we can argue, my lord. If there is no point, certainly we cannot argue, my lord. Unnecessarily, we cannot
That's the beauty
waste
of,
the.
that's the beauty of that side. Even if you don't have
No,
a point.
we know our, we have also got certain limitations, my
No,
lord.
you-
My lord, unless we are satisfied, I myself is satisfied that there is a point, my lord. I should not waste the time of the court, my lord, unnecessarily, my lord.
Yes, I'll pass the order. Huh?
My
I'll
lord,
pass the order.
my lord, just I am putting it otherwise, my lord.
Yes.
My lord, your lordship knows 227. I have a statutory right to file an application for discharge, my lord. Discharge on what basis, my lord? My lord, presuming that what the charge sheet has been filed, the charges will be, my lord, framed as per the charge sheet, my lord. So I am filing a discharge application to discharge me under section 306, not under 302, my lord. My lord, if subsequently 302 is taken, my valuable right to approach the court for discharge.
I'll take care of your apprehension also, while watching the orders. Don't worry about it.
My lord,
I'll take care of
the
your apprehension. I understand the
entire
prejudice part.
thing, my lord.
I understand your prejudice part. And to cover up that, I'll take care of that situation
My lord.
also while dismissing a petition. But I'll observe something.
But
Leave it to me. I'll
fact
just see.
remains that the charge sheet has been submitted, my lord, the postmortem report. That is why, my lord, your lordship had called for the postmortem report
I know.
to find out whether it is a suicidal death or it is a homicidal death, my lord. Your lordship, they have got the charge sheet. Your lordship may kindly look at the charge sheet. Charge sheet clearly says it is a suicidal death, my lord. My lord, there is no injury, nothing of that sort, my lord.
I'll
It's
pass.
a suicidal death.
I'll pass by.
On the basis of the charge sheet,
I'll
your lordship may
pa-
pass whatever order,
I'll
my
record
lord.
your statement and pass.
And-
Appropriate order. Don't worry.
And if your lordship will kindly look at another decision of the Honorable Apex Court, my lord, where it clearly says, my lord, point of law has been decided there, my lord. Your lordship may kindly look at paragraph 8, my lord. I'm just previous page, if your lordship will kindly turn to.
Para 8.
Right. At the time of framing, your lordship got it, my lord. At the time of framing of charge and taking cognizance, the accused has no right to produce. I'm not concerned with that, my lord. And call upon the court to examine the same. No provision in the court grants any right to the accused to file any material or document at the stage of framing of charge. Then this is important, my lord. The trial court has to apply its judicious mind to the facts of the case as may be necessary to determine whether a case has been made out by the prosecution for trial on the basis of the charge sheet material only.
Yes.
So whatever charge sheet material is there, my lord,
I go
only on
one
the
step
basis of
ahead.
that, my
I go
lord.
one step ahead. A judicial magistrate or any court for that matter has to apply judicial mind in every case, every situation.
Every
Even
case,
in
my
small
lord.
application.
And
For
to
either
what,
purpose.
my lord? And to what, my lord? The charge sheet material only, my lord. Not beyond that. They cannot, my lord, now widely discuss and find out whether this, my lord, section is not made out or this that section is made out. Therefore, I can take cognizance of that. Because 216 and 217, if your lordship kindly refers to, my lord, there is a provision.
Supposing I'll pass 302
Yes,
today.
my lord. Yes, my lord.
And eventually when the evidence are recorded, okay, material comes.
216 is there
Then
for
the
the
same
prosecution
situation,
to
same
file an
situation,
application. The
what
court
is-
can
what is
alter the
grading?
charge.
So it is always contingent upon the evidence likely to come.
No, my lord, there will
Either
be.
you quash it today or you may not quash it today, but it is every time it is contingent upon the evidence comes. You
But-
know that.
But
Today,
216
what is
provides
the theoretical situation
alteration
you are
of charge,
creating today?
and 217 provides that the
therefore-
court can recall
Therefore,
the
if material
witnesses.
doesn't come, then you out. If material comes, then even if I quash today,
Of course, my
tomorrow
lord,
you will be in.
they cannot, my lord,
Why are you wasting time?
I cannot be convicted solely because of, my lord, the medical evidence.
Yes.
So, my lord,
there you are correct.
otherwise my prejudice will be, your
You
lordship,
cannot be convicted,
my
but
lord,
in
if it is-
charge can be framed.
my lord, otherwise prejudice, another prejudice will be, my lord, I am losing a forum also. Because why I say, my lord, if it is a case under section 304B 306, my lord, the case may be tried by a assistant session judge, my lord.
You get a better forum.
And I get a appellate forum before the learned session judge, my
Yes.
lord. Thereafter, High Court, thereafter.
I'll pass next time.
So that is also another part your lordship has
I'll
to.
take care of that.
Yes, my lord.
Yes. Next. Yes.
21.
21. Yes.
Your lordship.
Yes.
Also include order at annexure 5. That is rejecting the application lesson. Lordship gives it.
I think some urgent call you attend that. I'll pass it on. Next. I'll pass it on. Yes. Next.
22.
22. 22.
22.
Attend that call that my
22 is also
while arguing again.
Not so 22 is also mine. That's the difficulty.
Yes.
I beg by beg part.
Yes. Yes. Tell me.
That's it. But summary of the inter proceeding and annex 2 also the include the order cognizance.
2.
Yes, no.
Yes.
Well, a very peculiar case. Here the case of involvement, in fact, it is a banking transaction. The petitioner is is the branch manager of a non-banking financial institution. The informant, in fact, availed a loan. When did not pay, the companies for the procedure went for auction. And since it did not pay, he defaulted. And thereafter she also filed a consumer case. Again, after filing a consumer case, here for he filed a 1cc case. Based upon that, the further procedure was launched and directions were registered, the FIR was made.
Yes.
And thereafter the order of cognizance was passed.
What are the allegations against you? You tell me. just.
Absolutely no, absolutely nothing, my lord. Here the relationship that I here, my lord, he is a customer before the bank.
Show me the charge sheet.
Yes.
Where is the charge sheet?
No, sir.
You don't show me like this. It has to be there on record. This is when counsel for
That is-
petitioner seeks to place on record the copy of the charge sheet. You are challenging cognizance order, so charge sheet has to be there. Let him place the charge sheet on record within 2 days. Please next week. Yes, next.
22.
This practice you have to stop giving. Now it is all digitalized.
No.
You have to file it. Yes. Next. 22.
That's it, here.
In item 22, you are there?
That's it. 21 term.
22, I'm talking about.
Yes, so I'm, in the second case I was arguing.
Yes.
22.
Yes,
Ah.
that was 22. Now 21.
You argue 22.
22, yes.
Okay.
Here, my lord, the impugn order at Annexure 4,
Hmm.
my lord, the rejection of application for 457, that was challenged. Here, the petition, my lord, is the non-banking financial institution. Here, my lord, in fact, it has many branches all over the India. In one branch, it is Cuttack. A robbery took place. That, and the petition company lost the FIR. On the basis of FIR,
Robbery in your.
yes, one of the branch at Cuttack, my lord.
Yes.
The industry was taken up, charges submitted, some accused persons are arrested, and some gold works was also recovered. Here, my lord, when I filed application for release, since that initial application was rejected, since that investigation was going on. That is, my lord. And Annexure, my lord, 1, page 18. Then I move, my lord, to the this honorable court, my lord. Let's see page 24, the order, as per this honorable court.
Yes.
There's a category observation, let's see para 3. As I'm just reading out, the petition, relevant portion. The petitioner company filed an application for petition CRPC through its authorized officer seeking interim release of the gold ornaments, which has already came to be rejected. Perusal of the impugn order reveals that the London court below rejected the application mainly on the ground that investigation was in progress, as also the fact that the beneficiaries are required to identify the gold ornaments, which needs to be matched with the database of both the gold loan branches of the company to segregate them and ascertain the original owner thereof. Such order was passed on 24th also.
Yes. Then what happened?
Plus, a copy of which has been enclosed Annexure 2, clearly stating that the cash and jewelry received are the properties of parent IFL company as the petitioner. And illegal transport to Manappuram finance branch by the accused persons. The above prime basis shows that the gold was the property of IFL in the legal sense of the term. Such fact was not within the knowledge of the London SDJ as the impugn order was passed 4 days earlier. Having regard to the above, the criminal revision is disposed of by directing London SDJ S. Sadar Cuttack to consider the application of some 450 filed by the petition reference. Taking
That report, taking into consideration that report, decide the application.
As it is.
And now you went to the court and which is rejected.
Rejected.
Where is that order?
Yes, that is my lord.
Order dated?
That is, my lord, page 26.
Yes.
My lord, very clearly it is observed that that the Honorable High Court has not directed for release. See, I am just reading out the relevant portion.
Hmm.
Plus, page 33, kindly see.
30?
Page 32.
32, yes.
Second paragraph.
Hmm.
Peruse the case record. It is found that nowhere the Honorable High Court directed to release the seized article in favor of the petitioner, rather directed to decide the matter afresh.
No, rightly, High Court has not said to release it. High Court says that you consider the AC
No.
report and take a call.
First, you would see the observation that clearly stated that it is property of.
No, don't rely upon that observation.
No, that is basic.
High Court only says that report says this,
Yes.
and this is not considered by the trial court. Let the trial court consider and pass the order.
That
Now show me from the impugn order what is wrong, what is right.
let's see
Forget
that.
about
Before that, kindly see, my lord, Annexure 2, page 22.
Where is that report?
Yes, that is there. That is
Yes.
Page 22, let's see, Annexure 2. Let's see if you read out the para 3, my lord.
Investigation is complete.
My lord, that,
Yes.
yes, my lord.
Charge sheet has been filed.
That specific instruction obtained by the IO, my lord.
Yes.
And the seized gold on the para number 6 in his instruction, my lord,
Hmm.
IO submitted that the seized gold relates to the master of branch of petitioner's company, except providing some data in respect of seized gold item, the petitioner company has claimed its release, my lord.
Hmm.
They did not produce document in respect of individual gold loan accounts in order to link them with the seized item during investigation and are playing hide and seek, my lord. And on para number 10 of the
Why
instruction.
don't you?
Confusing.
No, not confusing. Why don't you give the loan documents?
Basing on our cooperation,
And also,
whenever they directed, we come, and on the basis of our cooperation, the entire proceeding, my lord, they carried out the road.
No, cooperation, obviously, you robbery
sir,
took place in
confusing,
your place, then you have to cooperate. That's not the issue. Issue is you give the relevant document for the purpose of
Yes, sir, madam.
verification so that it will be released.
for
Why
the
don't you give it?
identification of
We
the
are-
gold, my lord, is very.
How there, perhaps they see, what I find, they're probably confusing. One part they're saying something, on the other part they're saying something. And I am reading out as para 3 or the in the above case, the cash and jewelry seized are the property of parent IFL company, illegal transfer to Manappuram Finance Branch by the accused persons by creating an organized crime which involves the complicity of the staff and employees of the Manappuram Finance Limited Branch. In course of investigation, the identification of many of the properties seized from the Manappuram Finance has been revealed to be the property of IIFL branch, and also that of the customers, those deposited their gold for the loan purpose in IIFL branch. Apart from financing a loan illegally, Manappuram Finance has no claim or right over the property. Hence, the release of the valuables in favor of the petitioner will be biased and not violating the law.
Whether the
And-
golds belongs to the customer or not, that
Yes,
that
that is-
mean.
yes.
For that, you have to give the
Details,
documents relating the loan.
my lord.
We are finance company. Why don't you give it? How much time will you take to give the document? They will verify and tell me. Finish. Unnecessary reading out pages
My
after
lord.
pages. Don't read all these things. Forget about it. You want a disposal of this
Yes,
petition on the basis of whatever material there are records? Or you want release of your gold? You take it simple. Give whatever they are asking. Within 1 week, you give all the documents, they'll seek instructions and tell me
My lord.
this court, I'll
My
release.
lord.
Simple, don't read all these papers. The fact of the matter is you are a finance company.
Yes.
A robbery took place and gold ornaments, everything was stolen. Now it is recovered. They want to know whether it belongs to the company or it belongs to the customer, those who mortgage the property. Mortgage. They want to ascertain. So suppose today they will the court releases to you. And what will happen to the customer whose gold has been mortgaged?
Yes, my
So
lord.
they want to ascertain that. Why are you not giving the papers? Reading this page, that page and all. How
I'll see.
And ଆପଣ କଣ ଦରକାର କୁହନ୍ତୁ? Police.
My lord,
The details identification of the gold belonging to the company, my lord, that
You give me that.
My lord.
Don't create any hanky-panky. Whatever they are giving, you decided, tell me. There is a report. You don't rely upon that report. Which paragraph? Para which para?
6, my lord, para number 6, my lord.
Para 6. Para 6.
6 and 10.
6, 7,
10.
my lord, 10 are the relevant points, my lord.
What are the documents you need? You tell me. So many pages. For what are the documents you need?
Initially audit reports will they should. So
You tell me what are the documents you need? What kind of document you need from them?
The list of
Who is interested in this big history? This happened, that happened. You tell me what are the documents you need. They will give you and finish it up.
Let me verify.
Yes. Then State Council submits that he would be filing in he would be filing details of the documents which are required to verify regarding the ownership of the gold element sought to be released. Within a week. Within a week. You file it here.
My lord.
And advance copy of the list of documents required to be verified shall be supplied to the council for the petition. If you have documents, you come here, give it, and I'll release it.
fix up a date.
I will fix it.
Free copy will be supplied.
Free copy.
Out instruction.
ଆପଣ ଖାଲି ଗୋଟେ ପୋଲିସ କୁହନ୍ତୁ ଏପଟେ ଛୋଟେ ବୁଲେଇବାର କିଛି
My
ଆବଶ୍ୟକତା
lord,
ନାହିଁ. And you create lot of pages, papers not going to the real issue.
my lord.
Issue is what are the requirement, what document you require, you tell me so that he will give it and verify and release it. And if there is anything, then we will ask for security.
My lord.
Some bank guarantee or some property security or something with indemnity, whatever,
Yes, not.
whatever. And release it. Yes,
23,
Kindly pass over, Lordship.
yes, password.
24,
Yes. 24. Cognizance order.
Quashing of cognizance.
Huh?
Quashing of cognizance. 24, my lord.
The cognizance order was that 27/11/2020.
My lord.
There must be nothing now.
Nothing now.
Charge might have been framed and everything might have
Yes, my lord.
passed over and will dispose it.
My lord.
27,
4 ବର୍ଷ ତଳେ cognizance what remained? 27.
Maybe, Your Lordship.
Yes.
Passing of FIR in connection with the Balipatna PS 250 of 17 manner. In the year of 2017, FIR lodge manner.
2017.
Yes, ma'am. Till today, no charge sheet manner.
What are the offences?
Offense 353, 35, 25, and 35 of arms charge. Police officer is informant manner. But till today, in the meantime, 7 years has already lasted.
Yes, sir. Are you really interested?
My lord.
7 years. No charge sheet. See, the petitioner is seeking quashing of FIR number so and so, so and so, so and so. The FIR was registered way back in 15/9/2017. However, till date, the charge sheet has not yet been filed, and investigation appears to have been going on. Therefore, the petitioner is agreed by the same and seeking quashing of the same. Issue notice to so and so accept notice for the state. Notice for the state. Next week, you take instruction. If you don't want, I'll quash.
My lord.
Copy the video.
7 years is more than enough. What are
My-
the offences, you know? 353, only 353.
My lord.
7 years.
25, 35 of arms track, my lord, is there.
Better to quash it,
My lord.
unnecessary way. Yes.
Your Lordship, item 25 second sub-item is 1 or 2 days to clear the defects. Your Lordship, I'll serve a copy.
There are defects, many defects, within 2 working days. Defects, all the defects pointed out by the registry, shall be cured by the petitioner within 2 working days.
Your Lordship. Your Lordship is posting it to 8.
Next week, don't decide the date.
Mm.
Leave something to the court. Otherwise, get your judgment also and tell,
Okay.
please pass
I
this.
apologize, Your Lordship. Is
Never even do, you are a young girl, never even tell the court that you fix this date or that date.
Mm.
You simply say, Your Lordship, can you accommodate me on this particular day, if possible? This is the
Lord-
way you should tell. Don't say that fix this day.
No,
This
Your
is
Lordship.
very bad approach.
Your Lordship, I just asked if Your Lordship is posting.
Henceforth, you do that, okay?
I apologize. Your
Yes, very good. Yes.
28.
My lord, in this case, my lord, the present petitioners
Yes.
are the petitioner number one is the wife of the opposite party and 2 is the daughter of the opposite party, my lord. And the the petitioners filed an application under section 125 CRPC before the family judge, Navarampur, my lord. And after getting notice, my lord, the opposite party filed counter that the present petitioner number 1 and petitioner number 2 are not the legal married wife and legal child of the opposite party, my lord.
Hmm.
For that, thereafter, my lord, the petitioners filed the application to for DNA test, my lord.
Hmm.
And the learned court below rejected the said petition. For
Yeah.
that reason, my lord, the present petitioner seeking direction to learned court below to conduct the DNA test, which has been rejected after said
What are the reasoning?
to ascertain the biological father of the petition number 2.
Show me the reasoning.
My lord,
Why
para,
it rejected?
para number 3, your lordship, page number 5, that it is further submitted that it is true to say that their marriage was solemnized on dated 9th, para 3, your lordship.
Impugn order.
No, para 3 of the petition, my lord.
Forget about it. Come to the impugn order.
My lord. That is page number 13 here. The case record is put up today for order in the petition.
Don't read full 10-page order. Just read the relevant part.
My lord, my lord, para two, my lord, that is the petitioner in his petition submitted that the above case is posted for hearing of the parties, and petitioner number 1 is the legal married wife of the opposite party, and the petitioner number 2 is the biological child of the opposite party. It is submitted that the opposite party filed his counter before the court. In his counter, he simply denied that the petitioner number 1 is legally married wife, and the petitioner number 2 is his legitimate daughter, and clearly denied in his counter that he is no way related with the present petitioner. The petitioner further submitted that it is true to say that their marriage was solemnized on dated 9/5/2016, and out of their wedlock, the petitioner number 2 was born at Christian Hospital, Navarampur on dated 18/9/2017. And at the time of marriage, the petitioner number 1 did not know the family of the opposite party, nor had any acquaintance of his nearest relative, and has no scope to know about the past of the opposite party. Further, the opposite party specifically denied the marriage with the petitioner number 1 and legitimate relationship with the petitioner number 2. He even denied that out of his cohabit with the petitioner number 1, the petitioner number 2 begotten. This plea of the opposite party created a devastating future for both the petitioner, and without father and without ascertaining the paternity of the child become called as bastard, and as such, the DNA test is eminent need to prove paternity of child. The petitioner further submitted that the petitioner number 1 is the married woman of the opposite party, and the petitioner number 2 is the legitimate child of the opposite party. And under section 112 of the Evidence Act, the presumption of legitimacy is this, that a child born of a married woman
and is deemed to be legitimate, it throws on
I
the
don't think any wrong. This order is correct.
My humble submission is that, my lord, after when the petitioner number one and two drop out from the house of the opposite party, the petitioner number one filed a FIR against the opposite party, which is pending since long, my lord.
Which one?
Which is pending since long.
What?
The criminal case, 490-day case, my lord.
That's a different story.
And my humble submission is that he never filed any quashing of that FIR in this honorable court here, lordship. For that reason, my lord, it is presumed that the petitioner number one is the legal married wife of the opposite party, and the petitioner number two is the legitimate child of the opposite party.
So why do you then you need a DNA for that?
As because, my lord, he completely
Because merely because your husband says that the marriage is not a valid marriage, therefore you want that your child should be subjected to DNA test. What is this?
He completely denied to.
Merely because he denies it, he has to prove. Why are you subjecting this child to this DNA test and all? This is not permission.
My lord, kindly admit the case and notice.
No. You can't subject this child to this DNA test and all. Because a fight between you and your husband, he says that I am not married to DNA test.
If this application will dismiss, my lord, the opposite party.
You tell me if you don't want dismissal, what else you need? You tell me.
My lord, in my lord, I have a judgment. I have reliance the judgment that is, my lord, Narayan Datta Tiwari versus Rohit Shekhar.
Forget it. Narayan Datta Tiwari. Everybody knows Narayan.
And the Tiwari case. And
you know what happened thereafter? After all these things, what had happened to that family? Do you know that? Because of this kind of attitude only, the entire family is spoiled. Will you withdraw or I'll pass order?
Permitted to withdraw, your lordship.
That council petition seeks to withdraw this petition.
Oblige, your lordship.
Yes.
29.
Don't do young child unnecessary subjecting to trauma to this child because of your ego problem.
29.
Yes.
Passing over FIR, my lord.
Yes. What is there? FIR charge sheet filed.
Well, that instruction.
Investigation is still going on. 23 October 23. Where is that? Nobody is there. You pass over. Next. Yes. Yes, sir.
Item 30.
Made, please.
Yes.
This is for passing of the case against me. But against the charges I have come, that petition having been rejected. But I am a retired DFO.
Yes.
The charge sheet I have filed.
Vigilance case.
Pass it. What? Shall I give a date?
Your lordship, give a date.
And only
Ask her which date will be convenient to you. Please say, tell her which is the date convenient to you.
Any date that is convenient to you.
No, I am here only. You just tell me whichever date you want.
I am here each and every day. Only last Friday I was not there because don't go. Yes, sir, proper
outdated.
80 Guruvar ko no
You do one thing, you come little later. Wait.
Next
And
week,
tell
upon
the date and
next week.
he let that and give it.
Any day to
One thing, Lordship may record. Now the for the self-same charges.
Same charges, departmental proceeding and vigilance inquiry was initiated. Charges were, it is absurd that as if DF I have failed to supervise.
Yes.
Now that was exactly the same self-same charge.
Departmental proceeding.
Department has completely
Exonerated
me. So that those.
I have
You filed those documents also.
Just now they given because I was
That,
not
that,
there
that
for that.
strengthen your case, then you
For
must
4
file.
days I was not there, for that reason I could not assist.
Let,
my
Mr. Vishwal and counsel for the briefing counsel for briefing counsel to Mr. Mohanty, the senior counsel, seek time to place on record the certain document regarding the exoneration of his client from the departmental proceeding on the self-same grounds. Self-same ground.
Next week, any date?
Next week.
Bloody interim order.
Interim order. There is an interim order. Yes, continue.
Adjournment petition.
Yes.
Oblige. 31.
Yes, sir. Bail matter, what is happening? Nobody is done. Yes, you were supposed to get instruction
My lord,
regarding
the instruction.
criminal antecedents.
Today he will send the update CD.
Huh?
Today he will send I will send the update CD. My lord. Today he will send.
Because this matter is pending since 2023. 1, 2, 3, 4, 5, 7, 8 dates have gone.
Only last chance, my lord, on the basis of last chance.
On last date of hearing, the state council was directed to seek instruction regarding the criminal antecedent of the petitioner, which has not yet been obtained by him by way of last opportunity. 1 week time is granted, least next week. Yes.
32.
May I please, Lord?
Yes.
Lord, undated 1.
Yes.
Undated 1, I submitted the charge was on that day, Lord, but that charge was on 29/8/2000.
What happened?
Lord, on that day, charge is not framed, Lord. And the DNA test is corroborated.
What do you want?
Only praying for the interim bail because he has once granted interim bail and surrender in time, Lord.
No, but there should be ground of interim bail, not that in the indirectly bail is not granted, so keep on going in interim
And
bail.
the charge is fixed on 29, Lord, for charge consideration of the charge.
Your bail application was earlier rejected?
No, Lord. This is the first bail application. That is one.
Trial court rejected.
Trial court rejected.
October, 16th
Yes,
October.
Lord. Yes, Lord.
Why don't you repeat your
Yes,
bail
Lord.
plea?
After framing of the charge.
I'll just
Yes,
record
yes,
that.
yes, Lord.
Mr. Padil and counsel for the petitioner submits that the trial court had rejected the bail application of the petitioner on 16/10/2023, and now the matter is settled for framing of charges. Therefore, he seeks to withdraw this petition to renew his bail plea after the charge is framed against him. If such application, bail application is moved, the same shall be considered on its merit. With this liberty, the petition is
Obliged.
Yes.
33.
My lord, the case is under section 20B2C of the NDPS Act, my lord.
Yes.
And the petitioner is in custody since 8/12/2023. And allegation against the present petitioner is that on the date of occurrence, he was standing on the roadside with one plastic jerry bag.
What is
And
the recovery?
21 kg 600 grams.
Yes.
Yes, madam. 21 kg.
Ganja.
Ganja, my lord.
20.
Just it submitted, my lord.
But
Obliged.
antecedent
My lord.
subject to
My lord.
subject to
Yes, yes, that is there. I have also obtained the instruction regarding the CA, my lord. Available CCTV data, based found he was not involved in any other cases.
grant.
Obliged.
Subject to litigation, subject to verifications of the entity.
Obliged.
Yes. Correct. Yes.
34.
He's in custody with 8/12/2020. So forget to write. Yes. Yes. Sir.
May it please.
Yes.
My lord, here, the petitioner is the managing director of a company, my lords, which is an interface company for making payments, my lords. It's like this Google Pay and
Yes.
other, your lordships are aware. Account Pay.
Paytm and all.
Phone Pay, Google Pay.
Phone Pay.
This is Pay One, my lords. Now, my lords, the job of this company is to take in money from the informant company and pay to the informant company.
I didn't follow. You take the money from?
My lords, for example, the informant company is a service provider.
Hmm.
It is providing services to various other companies. Now, those companies will make payments to the informant company. They will make the payments through me.
Yes.
The money comes to my account.
Oh.
Whatever the amounts are due to the informant company, they come to my account, and T+1 means today is the transaction. By the next day, I have to clear up all the liabilities.
To the other service providing company.
The informant company.
Informant company.
So, Malams, I have a password for pay in for the informant company. For example, ABC company own the informant company, let us say 1 crore of rupees. I have the password for taking in their money, and I have the password to pay out money to the informant company. I do not have the password or the logistics for payout of from the informant company's account. That means, for example, I get ABC, I get, let's say, 1 crore of rupees. I have the passwords for taking in
Of
that
that 1
money.
crore rupees.
1 crore for taking in that money. I have the password for giving it to the informant company. But suppose the informant company wants to make payments to another, let's say, X, Y, and Z.
You don't have access to his account.
I do not
That's
have
what.
access. Exactly, Malaz.
Yes.
I'll read out from the charge sheet. That is exactly my case. Now it appears that an amount of 12
From
crore,
some money is taken out of their account.
their account.
Therefore, they say that you
They
are
say
interface.
that
Therefore,
we have done it. Now, how is it possible on my part to do it? It might be their employees, it might be other hackers. Malaz, I'm reading out just the relevant portion of the charge.
who are you, by the way?
I'm a gateway.
You
I'm
are
a gateway.
no. Karan Kumar Singh. Who is he?
Director of that.
How many directors are accused?
2 directors.
Both of them are accused.
Only one is in custody.
My lord, may I pray, my lord, one? Let it be taken up tomorrow because I was conducted this case. I have prepared some graphs made that how the manipulation was made.
Is in custody since
6/7/23.
6/7/22, about 1 year.
My lord, that and even my lord, what I have recollected, my lord, that some lakhs rupees were seized by the petitioner by the informants company, my lord.
Okay.
But they have not claimed.
What is the extent of embezzlement?
14 crore, 14 crore.
13 crore.
13 crore.
14 crore.
11 crores.
14 crore, 53,000. 25
11
lakhs.
crores, 49 lakhs.
Have you investigated from their account?
Yes, yes,
what are the amount
ma'am.
recovered or anything of that sort?
Yes, yes, ma'am. Some of the amounts were in their wallet, ma'am. That wallet amount was seized by the informants company.
Okay.
But he has not claimed that you return my wallet amount. He has not claimed. Why they have not claimed? Because crores of rupees was transaction was made. And how, my lord, that fraudulent transaction was made? I have prepared a graph, my lord. Let it be taken on, my lord, tomorrow. I will.
But keep it in mind that these are the offences where the entire evidence is documentary in nature. Documentary in nature. So you must tell me whether any custody is required or anything other sort.
Yes, yes.
Yes. Right. I'll put it. Let him. Next week.
Next week.
Council for the state submit that he would place on record the manner in which the transaction, alleged transaction has taken place. Therefore, he seeks 1 week time. Reach the matter Monday, Tuesday. Yes.
Monday about it about?
Tuesday.
Wednesday?
Tuesday.
You tell me
yes,
how this has been done,
yes,
and all the documents, whether you seized or not, what else you need from them, whether custody is required, further custody is required or not, all this is.
Only have taken instruction at the period, they would only refund that amount. Only that company claim is that only he refund that amount, which they have manipulated. Because some of the amount was seized from the wallet, rest of the amount he has to pay. That is his claim.
Whereas the amount means 11 crores or something.
My lord, within 15 or 20 days, this transaction has made. Crores of rupees transaction.
What are the other recovery?
Now, Olga Lokupova, anyway, let him explain on that. Olga Lokupova to seize custody. How does it, how do I come into the picture? Anyway, let them explain.
Yes. Yes.
My lord, 13th.
No. Next.
And this is not the only company I work for. I have various other companies. Oh, what they are saying, what they are not saying.
You are only director in this particular company where the
No, only-
interface company.
But
The-
this company works for various other companies as an interface.
Yes.
Hon'Ble.
35.
Yes. Yes. Non-APS for the petitioner in the interest of justice list next week. Next week for the week. Next.
36.
Display board देखते रहना. Yes. Same. Another piece of the petitioner need to submit list next week. Yes.
37.
Pass over. Okay. Next.
38.
Wait, please.
Yes, sir.
No, let's see. Your Lordship has heard this matter earlier. Last date, your Lordship directed Mr. Mohan to take time whether, well, in this case, the directors has been released on anticipatory bail.
Okay.
I am an accountant. Last, so your Lordship wanted them to know they have gone against that order.
What happened to that, Mr.
Apex Court.
What happened to that case?
It has not yet been taken up.
Well, defects has not yet been removed in that case. I am giving that status report.
Status report, Miller. Yeah.
এটা চার্জটা এটা হচ্ছে কোর্টে হ্যাঁ
What is your instruction? The small defects, why are you not curing?
Millard, it is, the information is that within this week, it will be after removal
I'll
of
put it next week.
Miller.
Because it's a case of parity.
Right.
So if that is happened, then they are.
Right.
It's a case of parity.
Your Lordship may keep it next week. Definitely.
as a last chance.
Submit that to the SLP with SLP against the order dated 9/2/2024, whereby the co-accused persons have been enlarged on bail. Is likely to come up for hearing before the Honorable Supreme Court within a week. Least the matter after a week. And it is made clear that no further adjournment will be given on this count.
Miller.
On this count. Okay.
If your Lordship excuse me, can your Lordship give you a date so that I
Date will be given. Date you will give.
adjust it in other courts?
Yes, please take the date from sir and intimate him. We'll give it. Okay.
39.
After 14 for a date or check on like you would.
My lord, I am ill today. I am unable to submit before this honorable court today. And 7 days time, my lord.
Seeks an adjournment on the ground of his ill health. Adjourn to. Yes.
7 days, my lord.
May I please your lordship?
Yes, sir.
Here, my lord, that alleged offences under section 20B to C.
CD has come. 1 minute. CD was called for. It has come.
I will.
I mean custody since 19/6/2023. 19/6/2023.
Okay.
More than a year. And my lord, that the contraband seized from the Bolero vehicle, that allegation that I am driving this Bolero vehicle, my lord, that pickup van, that is 417 kg of the ganja. And I have no criminal antecedent. And status of the case, that in the meantime, charge sheet has already been filed, charge has already been framed, and out of 10 witnesses, 1 witness has already been examined, and he has not supported the prosecution case, and this examination was made on the month.
When your bail application was rejected by
My
the
lord,
court?
my bail application was never rejected, my lord.
No, trial court.
Hello?
Trial court.
Trial court, my lord, my bail applications was rejected, I have annexed.
Uh-huh.
So
11
1
24.
2024.
When the witnesses were examined?
July, my lord.
July
Month of
2024,
my lord.
24.
Again. That, my lord, I have no criminal antecedent, and I am not an outsider also. I am belongs to this, in my.
Lord, 470 kg ganja has recovered. He was from his position, my lord.
But who is that witness who is not supported with it?
I have not
Who is
out
that
of
witness?
My lord, 1 witness is.
Who is that?
His name.
the official witness.
The name I have not, my lord.
You do one thing, you
But
go
as
to
per-
trial court and I am recording that. Trial court has to consider on the basis of available material only.
My lord.
During the
My lord.
petition.
My lord, my humble
Yes.
submission, my lord.
I'll give you sufficient breathing space, you know. First, second part of it. During the currency of the trial, material, it is, land counsel for the petitioner submit that during the currency of the trial, material witnesses have been examined.
No, 1 witness.
meantime. Material witness has been examined in the meantime. The by the order dated 11/1/2024, the trial court has rejected his bail application, for which he had approached this court, this court. Since in the meantime, the trial has advanced, it would be appropriate for the petitioner to approach the court below, renewing his bail plea, if such bail is moved before the trial court should consider the same on its merit on the available material which has come on record. Petitioner is in custody since 19/6/2023, and the trial is moving in a very low pace. Therefore, the petitioner's appearance that his custody will be prolonging in the pendency of the trial. Since the petitioner has already undergone about a year's time, it is expected that the trial court should decide its bail application expeditiously on its own merit. With this observation, petition is disposed. Next, yes. 47. Next.
And my lord, one thing, I pray before your lordship for observation, my lord, that he has no criminal antecedent.
He further, the land counsel for the petition further submits that although 400 kg of
417
kg of contraband alleged to have been seized from him, but fact remains that he is not involved in any other case. He has a clean antecedent entitling him for grant of court.
And he also belongs to that area, not outside.
That is there already. Right. Yes.
41.
My lord, maybe.
Yes.
Here the petition has been subscripted under section 376(2)(n), 376(3) of IPC and section 6 of the POCSO Act, my lord. Notice has already been issued to the victim. Notice has already sent to the victim, my lord.
Notice was issued?
Yes, last
service.
Confirmation letter with me, my lord. Yes. Notice, sir.
Yes.
Here, my lord, what happened in this case? The occurrence was.
Show me 164.
My lord.
Yes, victim has been examined.
Examined?
Yes, my lord. That is
show me the evidence. When he was examined?
Yes.
He was examined, rather.
21/2.
21?
February 2024. What happened in this case, my lord?
Before that, in January, your bail application rejected. You should go to that court, court of first instance. After this,
They married, my lord. They married, living together. And after about 21 months, she alleged that the petitioner kept her in the cow shed and ill-treated her. And alleging that she left my house. And thereafter lost ever after 21 months of the occurrence. And the petitioner want to take back her.
That's right, but age is very.
That's right, my lord.
That's right.
That is the difficulty.
And see, right, during the money, white order dated 9/1/2024, the trial court rejected the application for which the petitioner has approached this court. The learned counsel for the petitioner hands up the evidence of the prosecutrix recorded on 19 February 2024. Since during the currency of the trial, since the material witnesses have already been examined, the petitioner should ideally approach the court of first instance by renewing his bail plea. Therefore, at this stage, I am not inclined to take the second petition, rather granting liberty to the petitioner to revive his bail plea before the trial court in view of the changed circumstance. With this observation, the petitioner is disposed. Yes. I'll just come.
That may be kept in record.
There is no record. Yes. Who are you, husband?
Under section 306.
306. Okay.
Usually, that the victim is the daughter of the informant. After lodged the affair in the police station, alleging therein that.
Where is the charge sheet? Show me. You say the FIR was 304B, charge sheet is submitted 306. You say, show me the charge sheet. What is the allegation against you?
Certified copy.
Certified copy is not required, sir. You give me. These are bail matters are necessary. What certified copy? Do you have?
Yes, yes, my lord, yes. Charge sheet file with 498A, 304B, 34/4 and 406 IPC.
304B is also
Milord.
there. What are the allegations against?
How
How he died?
Hanging, my lord.
Hanging.
Yes. What happened, my lord? As it appears from the case diary, death is authorized at normal circumstances, my lord, within 2.5 months of his marriage, my lord. Statement of the Ravindra Maharana, my lord, who is the father of the categorically stated, my lord, ବିବାହର 8 ଦିନ ପରେ ଝିଅକୁ ଅଧିକ 1 ଲକ୍ଷ ଟଙ୍କା ମୋ ଠାରୁ ଯୌତୁକ ଆକାରରେ ମାଗିବା ନିମନ୍ତେ ଝିଅର ସ୍ୱାମୀ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଜିତେନ୍ଦ୍ର ଶ୍ୱଶୁର ଦବାକୁ ମତେ ବାଧ୍ୟ କଲେ ମୁଁ ଅନିଚ୍ଛା ପ୍ରକାଶ କଲି 14/6/23 ତାରିଖରେ ମୁଁ ସେଠାରେ ପହଞ୍ଚି ସେମାନଙ୍କୁ ବୁଝାସୁଝା କରି ମୋର ଆର୍ଥିକ ପରିସ୍ଥିତି ସମ୍ପର୍କରେ ଅବଗତ କରି ସମୟକୁ ଅପେକ୍ଷା କରିବା ପାଇଁ ବିନୟ ହୋଇ କହିଲି। ଗତ 17/6/23 ତାରିଖରେ ଝିଅ ଜ୍ୱାଇଁ ରେଙ୍ଗାଳି ଥାନା ଅନ୍ତର୍ଗତ ରମ୍ପିଲା ଗାଁକୁ ଗଲେ। ମୋ ଜ୍ୱାଇଁ ଏନ୍ଆର୍ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ହାଇସ୍କୁଲରେ ଟିଚର ଅଛନ୍ତି। ଅଧିକ ଯୌତୁକ ନିମନ୍ତେ ଝିଅ ପ୍ରତି ମାନସିକ ଶାରୀରିକ ନିର୍ଯାତନା ବଢି ଚାଲିଲା। ଶାଶୁ ଓ ସ୍ୱାମୀଙ୍କର ନିର୍ଯାତନା ଅସହ୍ୟ ହେବାରୁ ଏ ସମ୍ପର୍କରେ ଝିଅ ମତେ ଅବଗତ କରିବାରୁ ମୁଁ ଝିଅର ଶ୍ୱଶୁରଙ୍କୁ ଅବଗତ କରି ସମାଧାନ କରିବା ନିମନ୍ତେ ଅନୁରୋଧ କଲି। ଏହାକୁ ଖାତିର ନ କରି ତୁରନ୍ତ 1 ଲକ୍ଷ ଟଙ୍କା ଦେବା ନିମନ୍ତେ କହିଲେ। 1/8/23 ତାରିଖ 11ଟାରେ ଜିତେନ୍ଦ୍ର ମତେ ଫୋନ କରି କହିଲା ତୁରନ୍ତ ଆସ, ଝିଅ ଶାଢୀ ଲଗାଇ ଆତ୍ମହତ୍ୟା କରିଦେଇଛି।
What is the circumstances? Bolted the door from inside, or what are the thought map indicating?
My lord.
Just see.
My lord. Not bolted inside, my lord. Because in that house, my lord, only husband and wife are residing, my lord. They are residing separately in the house, my lord. Only present petitioner at the time of occurrence was present there, my lord.
Only petitioner was there.
Yes, yes.
How many accused? How one accused.
No. Accused others are there, my lord.
What happened to those accused granted bail? Anticipatory bail. So where is that? Those orders? Neither you have filed the charge sheet, not the order of co-accused persons, nothing. Only one FIR finished. Grant bail. At least these are relevant documents you should file.
And there
Don't
were
give, there is no filing.
high injuries in the body. Some injuries in her body, my lord.
I am having for certified copy of the deposition.
I don't need any certified copy, at least photocopies, at least you place on record, and the co-accused, those who have been granted bail, file those orders. Whatever you file those records, let the counsel for the petitioner seeks to place on record the copy of the charge sheet and the orders by which the co-accused persons have been enlarged on anticipatory bail, deposition, whatever. Leave the matter after 1 week. File it so that you are entitled to bail 1 year already custody, and file all documents so that he will give a date next week. Huh? Next week. Yes, file the document. Yes, next.
43.
And medical document also you file. Let us see what are the injuries. Yes.
43.
Any suicide note, anything recovered?
Miller?
Suicide note recovered? Yes. नहीं what illness? OPD patient. What has happened to you? What has happened to your wife? Oh, this small. Oh. These are if you go to OPD, they'll write everything.
Here, case, my lord. NBW issued 2015, my lord. He arrested on 2023, my lord.
Offense?
110 kg ganja from his house found, my lord.
And I am the employee of the postal department. There is no chance there.
What is the says?
Stage, my lord, rhyming, no instruction with me, my lord.
What is the stage?
Rejection ta dekho.
Obviously, 2013 matter, you were absconding, NBW issued, thereafter you got arrested. So obviously, you will be there in the custody only. What is the stage you tell me? Stage up for the trial. Do you have any idea? You also have not filed even a FIR also. Only rejection order, bail application. Finish. And you want to argue everything on the basis of this. How will you substantiate the You have to argue the case on the basis of material on record. What are the material? Nothing. You have not filed anything. Not even FIR copy. You file a better one.
Miller.
See, your bail application was rejected way back in January 2024. better you go to the court of first instance and file all the documents, try to argue on merits and invite an order. If I reject, then the even trial court will not give the bail. Try to appreciate you are bargaining a risk by arguing the matter here without any materials. Right off. I'll just give you that opportunity, you go. Then counsel for the petitioner seeks to withdraw this petition to revive the bail plea before the trial court in view of the fact that the trial court had rejected the bail application on 16/1/2024, and there are many changed circumstances. Therefore, he seeks to withdraw the same to avail the remedy of renewing his bail before the trial court. With this liberty, the petition is here.
44.
Right. Recovery?
154 kilos.
Okay.
Of the ganja from a Scorpio, where he was a passenger. 4 persons were there. Remember?
Anybody out of them got bail? None of them.
4 persons are there, my lord, or belong to Maharashtra, known to each other, my lord. Same area, my lord. So he cannot take plea that he is a passenger, my lord.
Which are the places they have visited in Koraput? The Maharashtra people, and for the north there are many people there coming here. Maharashtra also started coming here. Because what is the problem in that area? That area is flanked by 2 states. One is Chhattisgarh and another is Andhra Pradesh. That is in between. So therefore, this is a very easy way of doing all these things. So that is the reason you will find in that area, Koraput, Malkanagiri and all area. And except NDPS case, there is nothing. And the trial courts are completely choked by this kind of matters. And most of them are from outside.
This person got bail, my lord. They will never come for trial, my lord.
That's the another problem. And as a result of which the other accused persons are suffering.
My lord.
And in many cases, what happens, the tribals are also involved in this case because of a small temptation from some money.
My lord.
And they languish in jail and these people get the bail and that's the reality in the ground.
But my submission trial may be targeted, my lord.
Let me submit now. Can you have a glass to place 34?
3-4, huh?
3-4.
Yes.
I find the tacit copy. They have kept it open, the investigation.
Yes.
173-8. But on the last occasion, my lord directed them to file an affidavit.
Affidavit has already been filed, my lord.
Show me the affidavit.
Yes, said that they have filed the charge sheet on 4/12/2023. But I have sought for the certified copy, and certified copy was issued me on 12/1/2024. This charge sheet, no final charge sheet was issued to me. But they said that they have already filed the charge sheet.
Yes.
We have already filed the paragraph from I mentioned, my lord.
No, have you
Final charge sheet was submitted in Nandapur PS case number on 1/12/23, but inadvertently in the final charge sheet it has been mentioned 4/12/23.
1/4?
1/12/23. Final charge sheet has been filed.
Certified copy on 12/1/2024.
Anyway, now forget about that confusion. The fact remains that in 1/12/2023 charge sheet has been filed.
Final charge sheet filed.
Yes. Right, you are right. And your bail application was rejected on 19/5/2023. So ideally you should go to the court.
1st January 2024.
Oh, 1st January 24. But we see the prayer. What have you written? Case number dated 23, okay. Okay, 1st January.
1st January. It's the annexed to my lord.
Annexed 2, huh?
Annexed.
Yes.
Delay there, my lord. This last 1 year they are in behind the bar.
Yes.
It says behind the bar. And though the charges, they claim the charges was filed on 1/12/2023. Till date, my lord, the 8 months is passed, but no trial has been taken.
This is where this is Korapur. In the imbue note, where does it say that the charge sheet is not filed?
It is mentioned, my lord, no doubt, charge sheet has already been submitted. Page 20, input order, my lord.
20.
My lord.
Subsequent verification on the there is there is no chance of no changing circumstances.
We'll let the material witnesses be recorded. I'll give a direction that material witnesses should be. Huh? Material witnesses.
Yes.
Material witnesses should
My
be
lord.
examined. Delay, see, what is delay? The FIR was registered in 2023. How do you explain delay? What delay? Delay is 5 years, 6 years, 7 years. You are there in the custody,
Right.
one can understand. It is not even a 1 year.
Charge is also not fair.
So therefore, I will say that material witnesses should be given recorded preferentially,
My lord.
and thereafter you revive your.
My lord.
Right. The petitioner is first two paragraphs. The petitioner is agreed by the order dated 5/1/2024, whereby his bail application has been rejected by the court below. It is submitted by the counsel for the state that on 1/12/2023 charge sheet has been filed. However, it is however it is borne from the record that the trial is not yet commenced. Not yet commenced. I am of the considered view that in view of the fact that the charge sheet has already been filed on 1/12/2000, final charge sheet has already been filed on 1/12/2023, and the petitioner is also petitioner is in custody since 19/5/2023. It would be expedient that the trial court should do well to see that the material witnesses, the evidence of material witnesses are recorded preference by giving preference over the what witness formal witness over the formal witnesses, and after the material witnesses are evidence of material witnesses are recorded, petitioner may revive his bail plea. The bail plea, if such application is moved, the same shall be considered on the materials available on document. Immediately, with this observation, this. You have not told me when the charge has been framed. You tell me when charge has been framed. Then only I don't know. You must tell. So therefore, targeting would be impractical. We'll see. Yes.
45.
Or shall I write if for the material witness, write down, if the material witnesses could not be if the trial court cannot record the material witnesses by within 6 months, after 6 months the petitioner may renew his bail plea. Within 6 months, if they do, it's all right. Otherwise, after you renew your bail plea after 6 months, we'll see.
45.
The material witness cannot be, evidence of material witness cannot be represented by the trial court for whatever reason, the petitioner can provide, huh? Yes.
45.
498 302 my lord.
302.
My lord. His husband.
Yes. Custody since? Copies of
Chatin
petitions
teis.
filed, all for the case ID. When the bail plea was rejected, rejection order. November 23.
My lord.
Evidences are recorded thereafter.
Evidence are recorded, my lord.
On?
We have given these copies.
Show me. Tell me. Date.
Date, my lord.
At the top it would be. Second line.
29/11/23.
Huh?
29/11/23, my lord.
29/11.
My lord.
Thereafter?
Thereafter 30/11. Thereafter 2/12. Thereafter 6/12. Thereafter 6/12/23, my lord. Eyewitness, my lord. One Bayani Singh, my lord.
Show me the evidence.
My lord.
Bayani Singh, eyewitness.
My lord. PW4.
The evidence of these witnesses are not considered by the trial court because all these evidences were recorded prior to the imbue order.
My lord.
Huh?
Yes.
But nothing is considered, it seems.
My lord.
Where is that? Earlier, he has approached this court has he approached this court? Because liberty was granted to renew his prayer after the examination of eyewitness.
Regarding earlier filing, my lord.
Nobody is coming to assess bail application right now. Non-APS for the petitioner. In the interest of justice, adjourn after 2 weeks. Nobody comes. Why should
46.
No certificate regarding earlier filing, my lord.
Let him come.
My lord.
46.
Yes. Yes, 46.
Here also 302, my lord. Let urgent letter.
Non-APS
Urgent, non-APS
non-APS
urgent.
for the petitioner in the interest of justice. After 2 weeks there. Chalo, take it. Next.
47.
My lord,
Yes,
the
madam.
matter is under section 498A, 304B, 306 IPC, and 4 of DP Act. The accused person is in jail since 23 March 2022. My lord, 23 March 2022.
Yes. 22.
22.
Okay.
Since 2 years he is in jail.
Yes.
My lord, the FIR is lodged after 6 days of the alleged occurrence, even after getting the information of admission of the deceased victim in the hospital for her burn injuries. Then, madam, sir, there is no dying declaration made by the deceased in this case. And it is purely the accident while she was cooking food in stove, and due to the burst of stove or wearing apparel caught fire, and she sustained injuries, later died during the burn injuries. As such, it was an accident, sir. Sir, after filing of this BLAPL, 6 witnesses have already been examined by the court, and the copy of the depositions I have uploaded.
Charge
My
has been
lord.
framed.
Ah,
Charge has
yes,
been framed.
charge has been framed. 8 prosecution witnesses has already been examined.
No, charge frame under which provision? 302 or 304B?
304B. 304B.
304B and 306 must be.
Yes.
Yes, because charge sheet has been filed under those provisions. It's not the case of 302 then.
No.
As of now.
Yes, as of now.
As of,
My lord, the informant is examined as PW2. The copy of the deposition is uploaded, my lord. In this, in his deposition, para number 7, my lord. It is not a fact that I have not stated before the police that at VSSA Bulla Medical, I met my daughter, and on being asked, she has told me that the accused poured kerosene on her and set her on fire.
Where are you reading, ma'am? I don't have those papers with me.
The copy of the depositions are uploaded on 4th July.
I have also not received, my lord.
No, ma'am, this is not there with me. And the prosecutor is also says he doesn't have that.
My lord, please instruct me to allow me some time only for 7 days.
You place it on record. In any case, 2 years you have already been there. And in the case of 304B, you may be entitled for bail. Place it on record. Place those materials on record. Okay?
Yes.
Or one sets of copy, my lord, deposition.
Yes. Supply the copy to the prosecutor also. It will be easier.
My lord, 7 days time. Allow me
7 days. No problem. Miss Anita Das, Learned Counsel for the petitioner, submits that she wants to place on record the depositions of the material witnesses in the present case to substantiate her case. She may do so within 2 working days and supply the copy of the same to the Learned Counsel for the state. Release the matter next week. Release the matter next week. You file it next week. I'm
obliged.
Yes. Yes.
Initially, the FIR was lost in the whole night. August 2023.
23. Okay.
FIR was lost.
Offense?
498A, 304B, 306 offenses along with more of the protection.
Yes. Nature of death? Yes. How she died? How she died? Hanging.
Death of disease due to combined effect of asphyxia and a venous congestion as a result of hanging.
Hanging. Show me the circumstances. How? Marriage after how many years of marriage? It is in the toilet.
Madam.
Yes.
After a few months of marriage, madam.
See, this has happened in the toilet. Just see.
Page 9, my lord, of rejection order, second paragraph.
whereas the case record statement of witness recorded 161 speaks about the incident and involvement of the petitioner in the alleged crime. The petitioner is the husband of the deceased in inside custody since 13/8/23. The occurrence took place within few months of the marriage. PM examination report deceased Pooja Behera surfaced that her death due to combined effect of asphyxia and venous congestion as a result of hanging. All the injuries are antemortem nature, consistent with ligature mark of hanging. Materials available record prima facie suggestion complicity of the petitioner's alleged crime.
It was a love marriage.
My lord, what happened in this
Not
case?
even
My lord? What happened in this case, my lord? The father of the deceased, my lord, again married to another lady, and they went to somewhere.
I know the grandfather lady.
She with her grandfather.
But
while she was in the-
it was a love marriage.
My lord, while she was with her grandmother, this petitioner used to come to the house, my lord, grandmother's house, and taken him from that place to another place, my lord, and married in a temple. Then returned back to the Bhubaneswar. While in Bhubaneswar, he demanded money for purchase of auto, my lord. For that reason, regularly torturing the victim. The
Demand from
deceased.
whom?
My lord?
From grandfather.
No, demand from the deceased. You bring money from your father. Father went away and he had somewhere else and with another.
Father has already abandoned this girl. To whom he asked the money?
Both father and mother.
My lord.
Both of them from the girl. This is by the age of 3 to 4 months. That she had admitted in her statement, the mother of the deceased. And I'm pressing one statement, one sister statement of the mother of the deceased, my lord. Relevant person. କିଛି ଦିନ ଭଲ ରହିଲ
Come to the page 27.
My lord.
Page 27, middle of this. The incident. He might have demanded dowry and all.
My
This
lord,
is
my lord,
498
my lord,
and all.
my
That, torture and all.
My lord.
Section 4. But I am only interested to know about 304B.
My lord.
What is his role?
My lord,
On
page-
subsequent day, that is 8/8/2023, again, quarrel took place between Ganesh and Pooja. But no other persons was present in the house.
My lord.
Suddenly, deceased Pooja got annoyed due to the torture, and on that day, in between 1 p.m. to 2 p.m., she rushed into the toilet
My lord.
and hanged herself
My lord.
on the beam by tying with a napkin. Tying with a napkin, I don't know. Immediately, Ganesh Patra, suspecting something wrong, forcibly entered into the toilet and saw Pooja was hanging. Yeah. Immediately, he laid down the Pooja and to the floor and called his brother so-and-so, so-and-so, so-and-so. This is what has happened.
My lord. In fact, my lord, in the charge sheet I have got, my lord, also case diary. I have read out some persons, then I got. So, Ganesh Patra and his brother Gaurang Patra are the profession of as driver. Kunti Patra and the wife of Gaurang Patra are used to the labor work OTA campus. The places Gaurang Patra is driving one auto and all are maintaining their livelihood at Bhubaneswar. Whenever Ganesh Patra take rest for driving, he used to visit his native village, Gudimal. Meanwhile, Ganesh Patra attended a new house.
All these things are all right, but he called his brother Gaurango, and both of them took the deceased in their auto rickshaw to the hospital where she died.
No, the law of relationship developed with them.
Simple case of 306.
That is true, but the
presumption because
304B is concerned, my lord. Soon before her death, my lord. Prior to that, there is a
presumption is there.
My lord, there is a parallel between the deceased and then only he went and committed suicide, my lord. Since the petitioner is the husband, my lord, he is responsible for the survival of the deceased, my lord. He has not taken the steps to not given better treatment and torture out of, my lord, when the physical mental torture, for that reason he committed suicide, my lord.
So he is in custody since 1 year custody. 1 year custody. So see, these are mental issues, you know. Love marriage, and she was frustrated because of the father abandoned her. All these things accumulated in her mind, and she has committed the. And this man tried to save her also. In the toilet, this has happened. So
But
her
demand,
role,
Demand is there, my lord, for
Demand
demand
is there, and all
illegitimate, for that is she committed suicide, my lord.
All these things are there.
There is no such other way except commit suicide, my lord. For that is she committed
I
suicide.
know. The petition, second paragraph is the allegation against the petitioner is the petitioner got married with the deceased on marriage.
They had not given, my lord, few months, my lord. In temple marriage.
Married.
Express in temple.
There was a love marriage. There was a love marriage, and it appears from the charge sheet that the father and mother of the deceased had abandoned her as a result of which the grandfather,
Grandmother.
grandfather and mother,
Mother.
mother brought her up. She fell in love with the present petitioner and married. Few months after the marriage, the incident had taken place. It is alleged in the FIR as well as the charge sheet that the present petitioner tortured mentally and mentally.
And demanding rupees 50,000.
Tortured, demanding 50,000 rupees as a dowry, and due to unbearable mental torture, the deceased has taken the extreme step. On the fateful day, from the reading
Before, my lord, on 7/8/2023, there is a quarrel, my lord. Quarrel, my lord, is
in the means that on 7/8/2023 there is a quarrel between the petitioner and his wife, that is the deceased. On the subsequent day, on 8/8/2023, again quarrel took place between the petitioner and the deceased, but no other person were present in the house. Suddenly, the deceased got annoyed due to the torture, and on that day, between 1 p.m. to 2 p.m., she rushed into the toilet and hanged herself on the beam by tying with a napkin. Immediately, the accused, suspecting something wrong, forcibly entered into the toilet and saw his wife, deceased, was hanging. Immediately, he laid down the deceased on the floor and called his brother Gorango. Then Gorango came with his auto rickshaw, and they both shifted the deceased to the capital hospital for treatment. But the medical officer declared the petitioner, declared his wife brought dead. Declared wife brought dead. Therefore, at the instance of the grandfather, who is the author of the FIR?
Father.
Instance of who has written the FIR?
Father.
Huh? Father of the deceased. At the instance of the father of the deceased, the FIR came to be registered against the petitioner, and the charge sheet is subsequently filed for alleged offence under section 498A of the 306 of the 304B of IPC. The petitioner is in custody since 12/8/2023. Regarding the fact that the petitioner has attempted to save the deceased when he saw that the deceased committed suicide, and he along with his brother taken him to the hospital to save her life. It indicates that the petitioner regarding it to save her life. I am inclined to enlarge the petitioner on bail, with the bail. Accordingly, the court in season shall grant so also, with the further condition that the petitioner shall not try to influence any of the witnesses, and shall not keep in contact with any of the material witnesses in the premises. With this condition, application will not. Yes. Yes.
49.
Sorry.
What happened in this is 376D, my lord. Notice has to go to the informant, my lord. And actually what happened is, my lord, there are so many accused persons, my lord. Some of the accused persons granted by the coordinate bench, and since offense 3 assisted is there, my lord, against them.
Then it has to go to that bench only.
That is, my lord, in view of the Pradhanjan case, my lord. It has to go to that bench. Since the petitioner ST caste belongs to ST, my lord, for that reason he has filed the BL appeal. But the co-accused person, those are granted bail, they have been implicated on discussion.
Where is that co-accused?
My lord, page 21.
Right on.
Order of this.
In the instant case, the coordinate bench of this court has.
That is the CRLA.
Whatever, let it go to what? Coordinate bench of this court had enlarged enlarged them on bail, huh?
Bail.
Enlarged them on bail. The petitioner has filed the present petition for grant of bail on the ground of parity in view of Pradhani Jana. Pradhani Jani versus so. Let the matter be listed before the on the same bench which had dealt with the bail plea of the co-accused persons, subject to the approval of the Honorable Chief Justice.
So that is, he's saying that assist not against him. For that reason, the coordinator bench also treated it as a file earlier on CRLA, but the coordinator bench converted it to BL appeal.
Whatever,
but in fact, that is the bail.
Pradhani Jana bail only you have to go. Same FIR. Same FIR.
Same.
Yes. Yes.
Item 50.
May I please, Your Lordship?
Yes, sir.
The petitioner is in custody since 1/7/2023. Initially, FIR registered under section 364(34) of IPC. My name was not there in the FIR. For during investigation, I have been implicated on the confession of the main accused, Your Lordship, one Rajiti Krishna, Your Lordship, and the case converted to 364, 302, 201, 120B, and 34 of IPC, Your Lordship. So, meantime, justice submitted, no trial started, Your Lordship, and more than 1 year custody. And so far, the prosecution case, Your Lordship, the main accused of this case.
In this case, my lord, so far as co-accused persons are concerned, my lord, their matter adjourned to 23/8/2024, my lord. And Mr. Bhanjadev arguing one case matter.
Please tell him with the
ABL appeal number 13607023.
Yes, please.
BL appeal 13607023. And also 4 of the co-accused persons also filed.
Right.
All the cases, my lord, adjourned.
Please tell him with that. Yes. Next.
51.
May I please?
Yes, sir.
May I please? 376(2) my lord, that is section 36 POSCO. It arises out of a complaint case, my lord. Basically, it is a case of elopement, my lord. And the victim and the present petitioner, both of them eloped, stayed at Bangalore for 2 days, and thereafter the complaint case has been lodged at the instance of the victim.
Custody since?
Custody, the petitioner was arrested on 12/12/2023. The complaint case was filed on the victim and the petitioner got married on 5/7/2021. And the complaint case was filed on 19/6/2023.
Complaint, huh?
My lord. And on 6/8/2003, the complaint case was sent under 156(3) for registration of FIR. And accordingly, FIR was registered on 6/8/2023.
Yes, show me.
The 164 statement, Lordship, my kind of.
Show me.
Whether I read out? My lord. I read out.
Read out.
My lord. Read my person. रघुनाथ पात्र जी कि मो बड़ापा पुओं शला मो सहित से मो बड़ापा घर को आसती एवं मते
what was the age at the time of recording?
17 years 7 months
at the time of recording of one scene.
My lord. No, time of recording 20 years. 20 years. But at the time of my lord, the occurrence, first occurrence, my lord,
what was your age by that time?
My lord, now my age is, my lord, my lord, 29.
Okay.
So in the year 2021, my age was 26.
21 when you married. 5/7/21, what was your age?
3 years less, my lord, 26.
26.
My lord.
She was 17.
17 plus.
17.
ଯେତେବେଳେ
Yes.
17 ବର୍ଷ ଚାଲୁଥିଲା ସେତେବେଳେ ମତେ କହିଲା ବାଙ୍ଗାଲୋରରେ ବହୁତ ଭଲ ଝିଅ କାମ କରୁଛନ୍ତି, ତୁ ଚାଲ ମୋ ସାଙ୍ଗରେ ସେଠାରେ କାମ କରିବୁ। ମୁଁ ତା ସାଙ୍ଗରେ 2020ରେ ବାଙ୍ଗାଲୋର ଗଲି, ସେଠାରେ ରଘୁନାଥ ଗୋଟିଏ ଘରେ ରଖିଲା, ମୋ ସହିତ ସ୍ୱାମୀ ସ୍ତ୍ରୀର ସମ୍ପର୍କ ରଖିଲା। ସେ ରହିବା 8 ମାସ, ମୁଁ ସେଠାରେ ରହିବାର 8 ମାସରେ ପ୍ରେଗନେଣ୍ଟ ହେଲି। ତା ଭିତରେ ମୋ ସ୍ୱାମୀ ମତେ ବହୁତ ମାରଧର କରନ୍ତି ଏବଂ ତାଙ୍କର ଘର ଲୋକ
Basically,
ମତେ
it is a 498
ଫୁସଲାଇ ତାଙ୍କ ଘରକୁ ଆସିବାକୁ କହିଲେ। ତାଙ୍କ ଘରକୁ ଆସିଲା ପରେ ସ୍ୱାମୀଙ୍କ ପରି ଶ୍ୱଶୁର ଦିଅର ସମସ୍ତେ ଛୁଆଟାକୁ ନଷ୍ଟ କରିବାକୁ ଚାହୁଁଥିଲେ ଏବଂ ମୋର
Was that when you married? Was that the opposite party number 2, the victim? And opposite party. The opposite party number 2 victim accompanied the petitioner to Bangalore on the promise by the petitioner that she would be working in a good place, Subsequently, on 5/7/2021, they got married and stayed as wife and husband. Out as a result of which there was a child.
Yes, girl.
When?
girl child
born on.
suppose 160 ବର୍ଷ ଷ୍ଟେଟମେଣ୍ଟ ହେଲା ବେଳକୁ 1.5 ବର୍ଷ ହେଇଥିଲା।
Born.
That is on my lord.
After this incident, the petitioner started torturing the opposite party number 2. Therefore, on 6/8/2023, the complaint case was filed under section 156(3) of CRPC. On the direction of the magistrate, the FIR has been registered. After investigation, charge sheet has been filed for offence under section 3, offence under sections 363/368/376 2N, 294, 506, 34, and section
366.
366. FIR जो भी है, read with section 6 of POCSO. I have perused the statement of the victim under section 164 CRPC. Most of these facts have been admitted by her. However, she stated that the family member of the petitioner's promised her to give a good life and called her to the matrimonial. However, the father-in-law and the brother-in-law of the petitioner and however the family members, instead of keeping her respecting and keeping her as a daughter-in-law of the house, started torturing. Therefore, she had to approach the court by filing the complaint case. The matter was taken up for hearing by this court on 22/2/2024, and the following direction was issued. Para 3, Para 2 and 3. Pursuant to the aforementioned order, the opposite party, counsel for the opposite party, APS and submits that he has already taken instruction from the victim that she is willing to stay with the petitioner. The petitioner is at present 29 years of old age, whereas the victim is now 21 years of age, and there is a child from the wedlock. The petitioner is in custody since 12/12/2023. In view of the fact that both the petitioner and the victim are willing to revive their marital life, marital life, and the fact that the victim has already attained the majority, it would be appropriate that the petitioner should be enlarged on bail to give a chance to their marriage, their marriage. In view of the aforementioned, I am inclined to enlarge the petitioner on bail. Accordingly, the petitioner shall be granted the exemption.
If the condition.
And with the condition that the petitioner shall make all endeavor to revive his marital life and shall not torture the victim in whatever manner. These things are neither here nor there. They don't want to. They don't know what to do.
52.
But keeping him in the jail also serve no purpose.
No purpose will serve.
Let him come out. Yes. 52.
Madam, I'm the husband and custody since 4/9/2023. Initially, the FIR was registered under section 498A, 304B, 302, 294, 34.
Charge sheet.
And charge sheet submitted, my lord, under section 498A, 304B, 294, 506, 34 IPC, and section 4 of DPA. Lords may kindly find running page 15, my lord. That is a copy of the charge.
What happened in this case, my lord? Actually, I have not received the case diary since first date 22 to 204. That has been adjourned by on the prayer of the.
I have already annexed all the documents. My lord. So far, the FIR, charge sheet, section, postmortem, everything I have annexed.
Without case diary, it's not.
They are taking time.
No.
A short date.
They have taken time, my lord, on first date.
May I pray one thing, my lord? A short date may be given because
the brother in Mr. Raghunath and counsel for the state submits that he has not yet received the case diary. Seeks 1 week time, release the matter of providing. Yes.
And next week, yes. Because what happened in the meantime, my lords, I want to bring your lordship knowledge, my lord, that what a very tax for and next week,
you are not worried that your wife has expired.
No.
Very much worried about your brother-in-law expired.
Next week,
your wife has expired, therefore you are inside. Try to convince the court and get out of
case of suicide, my lord.
Without CD in
my lord,
this kind of case.
Only I pray, my lord.
They have taken time.
Only I pray, only I pray.
Have patience. Next week we'll see.
Next week, my lord.
If you have a case, definitely.
Next week, my lord.
Yes.
Date may be fixed, my
lord. Give a date, don't worry.
My lord.
Yes. Next.
53.
Yes, sir.
FIR on 29/8/2023 under section 376(2)(m), 307, 343, 25, 325 IPC Act.
307.
307. Charge sheet on 26/10/2023. Same application. 307 is simple injury.
Where is 164? Is recorded?
My lord.
Case diary is there?
My lord.
Let's see what is
164 statement, my lord. She has my lord, she has narrated everything, my lord. But her deposition, my lord, he has supplied to me, my lord, as PW1, he has not stated anything against the undeclared hostile.
So then, why should you keep him? Why should you keep him? The petitioner is.
This certificate copy may be kept in the.
Yes. Certificate copy, no, it is there. It is there already. It is. No. The position. I will record it. I peruse the certificate copy, but it is there on the record. She is 30 years old. Her name is Anita. Show me the certificate copy where there are overwriting. I don't know. Why is this overwriting?
Exactly. In my copy also overwriting.
The certificate copy is not. Have you checked it up? Let us see any variation. No, I don't think there is any variation.
Certificate copy kept in record, but so that
I can't because there is nothing to keep in record because we are paperless. If there is file, I can put it there. There is no file. What to do? But
Already
this,
filed.
that is there on record, right on. The petitioner is accused in FIR so and so. Second paragraph is it, and the allegation against the petitioner. Although the allegation made by the petitioner in the FIR is being reiterated by her in the statement recorded under 164 CRPC. However, when
One FIR 161, 160 same, my lord. But her evidence.
However, when she entered into the witness box, by the way, when your bail application was rejected,
Prior to recording her.
Then you have to go to trial court. I'll record that. You will go to trial court with the first instance. I'll record it. She has not supported the prosecution case, as a result of which she was declared as a hostile witness to the prosecution. Hostile witness to prosecution. The victim's statement was recorded being a PW1 on 5/3/2024, whereas her bail plea has been rejected by the trial court on
12. 2 months.
Therefore, while deciding the bail application by the trial court has no advantage of looking into the evidence deposed by the prosecutrix before the court. Therefore, I'm of the considered review that the petitioner should approach the court below by petitioner should renew his bail plea before the court below, being the court of first instance. If the petitioner moves bail application, the trial court shall consider the same in the light of the fact that the prosecutrix has not supported the prosecution in the witness box. With this, the petitioner is to write. You go. I have recorded. You will get it.
Religion dental. Direction may give religion dental.
Obviously, I can't give that. I have recorded. You will have to be released on bail. There is no option. 54. Right on FIR 161 and 164.
What are these?
All the things. Yes.
54.
Madam,
Yes.
20B, 2C and 29 of the NDPS Act.
Yes.
52 kg, 200 gram, including jury bag.
62.
52.
52. Okay. Custody since?
Custody matter since 30/11/2023.
30/11/2023.
He is a government teacher who is working in the school. He has been taken into custody because he is the owner of the vehicle.
You are supplying to the students.
Owner of the That's not
Owner of the vehicle.
owner of the vehicle.
You are not found in the.
No.
You are teaching in the school by that time this activity. I think.
That's fine.
But the vehicle, my lord, seeing the police, my lord, all of them carried away the vehicle standing there and the police person out there and recovered.
Left the vehicle.
And a verification found that the person is the owner of the
Owner
vehicle.
of the vehicle.
But he was not there.
No.
Nobody said.
Right on. Petition is accused in FIR. The vehicle from which the contraband, how much contraband? 52.
52 kg, 200 gram, including jury bag.
52 gram contraband was recovered.
200.
The petitioner alleged to be the owner of the vehicle from which 52 point so contraband of ganja was recovered. It is the case of the prosecution that when the police quoted the accused persons, all of them fled away from the spot, leaving the vehicle along with the contraband. After verification, it was found that the petitioner is the owner of the vehicle. Then counsel for the petitioner submits that the petitioner indeed is a teacher working in a school. Which school? Government school.
Government school.
Teacher and working in government school. He has nothing to do with the crime. Nothing with the crime which has been committed by the other political persons. The petitioner is in custody since 30/11/2023. Regarding had to the fact of regarding to the fact regarding had to the length of custody, the contravention fees, so shall be granted bail. This is
What is the ganja matter? Net weight matter the 50 kg 500 grams.
500.
50 kg 500.
Granted.
55.
Yes, sir.
Offences under section of for petition 380, 455, 294. This is IPC to do 50 of PDF Act. The petition or changing the the second January 2024. The petition is under section under custody in 2nd January 2020.
Yes.
24. The petitioner and the complainant is it some personal disputes. So is it taking advantage? And
What are the allegations you tell me? What are the allegations against you? What are the allegations, sir?
Or they have already entered inside the courtroom and taken a court records and burnt it. That is the allegation. For that reason, they are in particular.
It is impossible. I have not broken the
And
petition.
also final charge sheet also submitted against them.
The petitioner, it is unable to enter this room because the room is closed. Petitioner is not broken these doors. The informant in the statement can get statement. The informant is broken the door. It is invaluable to enter this.
Page 18
courtrooms.
mention.
Mir Kumar Das, huh?
Paragraph 6 of the
Para?
Paragraph 6.
Yes.
The material affair reveals that the informant, namely Vijay Malik, is working as a night watchman in the courtroom NGR Rajnagar on 30/12/2023 at about 3 p.m. While the informant was present in the court premises, suddenly the present accused petitioner, Mihir Kumar Das,
Space car of the court, namely so and obscene language, and under the influence of liquid saying so, and then the spot with anger. On the same day at about 9 p.m., the informant had been to the house of Peskar for dinner. While he returned to the court, he found fire and smoke coming out of the window in the courtroom, and he found that the main door of the courtroom was locked from inside, from which the informant
jumped from the roof and
breaking out
of the court and fled away.
Some records were set in fire immediately. Who had seen it?
Are the watchman, my lord?
My lord,
Vijay Malik?
it is unbelievable.
He found some of the records were set fire. Immediately, the Peskar, when Peskar reached at the spot, they both tried to extinguish the fire. So, for the accused, they found that the accused petitioner jumped from the roof and of the court and fled away.
They found that.
My lord, the Peskar, my lord, came there, my lord, after receiving phone call from the watchman, my lord. There are the allegations, my lord. Though the offense, my lord, the 335 is there, my lord, very much, my lord, prime facie 435 is made out, and so also 380 other offenses made out. It is, my lord, the subject matter of the court, my lord.
That is what is worrying. Otherwise, he is entitled.
If he will come back, release from bail, my lord, then, my lord, everybody dare to, my lord, the
court premises, everybody can get in and burn everything.
Since it is a court record, my lord, for that reason, my lord.
That's the problem.
Otherwise,
you are entitled to bail.
My lord.
No, it is invisible. False allegation because with the two-star building, how can the two-star? Only two-star building, my lord. 25.
That is not false, my lord.
Adjourn it for 1 more month. After 1 month, I will see. 1 month, September. Wait. After 1 month, you are entitled. I am saying that you are entitled. If had it not been a court, I would have straight away granted you. Because 380, 330, 435.
Because of personal dispute, the
we all
sweeper
are-
and informant.
We all are respect to the court and also.
That is the
I-
reason.
myself was respect to the court because the
Two things is coming in your way in the story. Before the incident, you came and started scolding him. Went for dinner. When he came out, you have done it
Sir,
and
he's
they
the
found
sweeper,
him
sir.
jumping.
informant and petitioner, both is the sweeper. For the
That-
personal dispute is arise between the informant and the sweeper.
What is
It
the
is a-
material personal this thing? What is, do you have any material to show that personal enmity is there? Any material? Merely
but-
saying will not help. Do you have any material to suggest that you have personal enmity with this Peskar or whoever?
Informant get is the statement, 161 statement says that he's the Peskar. And the-
One month, after 1 month, I'll give you.
Yes,
Yes.
56.
Well, the petition is custody from 4th September 23, my lord.
Yes.
The offence is under section 366, 376, 3,
Okay.
376, 2N, 506, and section 6 of the POCSO Act. Both the victim and the accused person are the neighbor, and they have the love relation with them, and they have the victim made a flight when she was out
Who is
of.
appearing for opposite party?
Alright.
Two.
Mr. Arun Kumar Budhia. After his present. Mr. Sonia.
You are 23. He is 55.
My lord,
You are 23. Age? What is your age?
my lord, the accused is 27 years,
She is 55.
55.
My name is there, but I don't have the file.
One minute, you are
In the-
Vokalatrama is there or not? Just
Yes, ma'am, that is the.
must be Vokalatrama.
Verify from the record.
His name is showing, huh?
Yes, madam.
56, huh?
Yes, yes, ma'am.
Victim is 15 years, sir.
Hmm?
Victim 15 years, sir.
15 plus.
15 years.
No, Vokalatrama is also there, sir. You file Vokalatrama. 1 minute, let him get instruction.
Yes,
You might have missed it. Next week, just note it down so that.
Yes.
Mr. Mishra, led counsel for the opposite party seeks an adjournment. Opposite party number 2 seeks an adjournment. Least thing. Yes.
57.
Okay.
May I please, ma'am?
57.
My lord. The petitioner being implicated in this case has been taken to custody on 11/12/2022, my lord.
Yes.
And the only material against the present petitioner is his own confession before police under section 27.
Okay. 302.
Yes.
Double murder case, madam.
Double.
Husband and wife both are murdered, killed in this case, madam.
Husband and
Wife. This is married. There are two
related.
Married.
If he is related.
Married. Husband, both the deceased are husband and wife. There are two dead body, madam. Found.
Now, who is he?
He is married related to them.
No. He is not related to the deceased persons. If my lordship will,
You are in custody
No,
since?
my lord, no, not related. Custody since 11/12/2022. Apart from the confessional statement of the present petitioner before police under section 27, there is no other material to implicate him. FIR is unknown. Yes. If my lordship will.
Yes, Mr. Raghuda.
27 statement, I am just reading it, my lord.
Yes.
The relevant part. मोर नाम धनेश्वर मुर्मू पुलिस हेफाजत थे उक्त केस रे साक्षी मान उपस्थित बयान दे जे मोर बापा मोर पीयूष पुओ भाई हमीर सोरेन आम गाँव बहुत लोक मानू आम गाँव बाहाड़ा मुर्मू गुणी करी
ଗୁଣି କରି ମନ୍ତ୍ରତନ୍ତ୍ର କରି ମାରି ଦେଇଛି। ଆମର କିଛି ଜମିକୁ ମଧ୍ୟ ଆମ ବାପାଙ୍କ ଠାରୁ ନେଇ ଅନ୍ୟକୁ ବିକ୍ରି କରିଦେଇଛି। ଗତ କିଛି ଦିନ ତଳେ ମୋ ବାପାର ଦେହ ଅତ୍ୟନ୍ତ ଖରାପ ହେଉଥିବାରୁ ମୁଁ ବାହାଡା ମୁର୍ମୁକୁ ମାରିବା ପାଇଁ ଯୋଜନା କରିଥିଲି ଓ ଆମ ଗାଁ ପାଖରେ ଥିବା ମହାବୀର ପୋଷି ଗାଁର ରବି ହେମ୍ବ୍ରମକୁ ବ୍ରାହ୍ମଣୀପାଳ ହାଟରେ ପାଇ ତାକୁ ମାରିବା ପାଇଁ କହିଲି। ସେ ରାଜି ହେଲା ଓ ମତେ 10,000 ଟଙ୍କା ମାଗିଲା। ମୁଁ ତାକୁ 10,000 ଟଙ୍କା ଦେଲି, କିନ୍ତୁ ସେ ଟଙ୍କା ନେଇ ଆଉ କାମ କରିଲା ନାହିଁ। ସେଥିମଧ୍ୟରେ ମୋର ବାପା ଓ ଭାଇ ମରିଗଲେ। ମୋର ବଳଦ ବିକ୍ରି କରିବା ପରେ ବାହାଡା ମୁର୍ମୁ ମତେ ସେଥିରୁ ଟଙ୍କା ଭାଗ ମାଗିଲା, କହିଲା ନଦେଲେ ଭଲ ହେବ ନାହିଁ। ଗତ ଶନିବାର ଦିନ ରବି ହେମ୍ବ୍ରମ ସହିତ ମୋର ରାସୋଳ ଛକରେ ଦେଖା ହେଲା। ମୁଁ ତାକୁ କହିଲି ତୁ କାମ କଲୁ ନାହିଁ, ମୋର ବାପା ମରିଗଲା, ମୋର ଭାଇ ବି ମରିଗଲା, ମୁଁ ଦେଇଥିବା 10,000 ଟଙ୍କା ତୁ ମତେ ଫେରେଇ ଦେ। ରବି କହିଲା ମୁଁ ଟଙ୍କା ଖର୍ଚ୍ଚ କରିଦେଇଛି, ଟଙ୍କା ଫେରେଇ ପାରିବି ନାହିଁ, ଆଜି ରାତିରେ ତୋର କାମ କରିଦେବି। ଆମେ ଯୋଜନା କଲୁ ରାତି 12 ଘଣ୍ଟିକା ବେଳେ ରବି ଆମ ଘର ପାଖକୁ ଆସିବ, ଆମେ ଦୁହେଁ ମିଶି ତାକୁ ମାରିବୁ। ଯୋଜନା ମୁତାବକ ରବି ତାଙ୍କ ଘରୁ ଗୋଟେ ଟାଙ୍ଗିଆ ଧରି ଆସି ରାତି ଆମ ଘର ପାଖରେ ପହଞ୍ଚିଲା। ଆମେ ଦୁହେଁ ବାହାଡା ମୁର୍ମୁ ଘରକୁ ଯାଇ ଦେଖିଲୁ ସେମାନେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଗୋଟିଏ ଖଟ ବାହାରେ ଶୋଇଥିଲେ। ରବି ଧରିଥିବା ଟାଙ୍ଗିଆରେ ପ୍ରଥମେ ବାହାଡା ମୁର୍ମୁ ମୁଣ୍ଡକୁ ଗୋଟିଏ ଶକ୍ତ ପାହାର ଦେଲା। ରବି ନଟ୍ ପିଟିସନର। ସେ ସାମାନ୍ୟ ପାଟି କରି ଶାନ୍ତ ହୋଇଗଲା। ତାର ପାଟି ଶୁଣି ତା ସ୍ତ୍ରୀ ଉଠି ପଡିବାରୁ ମୁଁ ତାକୁ ଧରି ପକାଇଲି ଓ ରବି ତାର ଟାଙ୍ଗିଆରେ ତାର ମୁଣ୍ଡକୁ ଗୋଟେ ପାହାର ଦେଲା। ତାପରେ ସେ ମଧ୍ୟ ଶାନ୍ତ ହୋଇଗଲା। ଏହାପରେ ରବି ପୁଣି ବାହାଡା ଓ ତା ସ୍ତ୍ରୀ ଧାନି ମୁଣ୍ଡରେ ଆଉ 2-3 ପାହାର ଟାଙ୍ଗିଆରେ ପିଟିଲା। ସେମାନେ ମରିଯିବା ପରେ ଆମେ ଦୁହିଁ ଜଣ ସେଠାରୁ ତାଙ୍କ ଗାଁ ଝୁମକି ପାଟିଆ ପାଖରେ କିଛି ଦୂରରେ ଥିବା ଗୋଟିଏ ନାଳରେ ପଡିଥିବା ହୋମ ପାଇପ୍ ଭିତରେ ଟାଙ୍ଗିଆଟିକୁ ଲୁଚାଇ ଦେଲୁ। ତାପରେ ରବି ତାଙ୍କ ଘରକୁ ପଳାଇଲା, ମୁଁ ଆମ ଘରକୁ ପଳାଇ ଆସିଲି। ଆପଣ ମାନେ ମୋ ସାଙ୍ଗରେ ସେଠାକୁ ଗଲେ, ମୁଁ ଲୁଚାଇ ପିନ୍ଧିଥିବା ଡ୍ରେସ ଆପଣ ମାନଙ୍କୁ ଦେଖାଇଲି।
What happened to Ravi? He got the bill.
No, Ravi in custody.
Ravi in custody.
Ravi in custody. He also, my lord, he is the principal accused, my lord. As well, he check out the plan and committed a murder of engaging the Ravi.
All these things are. What are the evidence you have?
Evidence, my lord.
Apart from the confession.
Prior to the occurrence, my lord.
Yes.
Evening, my lord. It is one witness, Krishna Chandra Dehuri, my lord. Relevant person. Krishna Chandra Dehuri, such and such, kala 9/12/2021 ସୁଦ୍ଧା 6ଟା ବେଳେ ଦୋକାନରେ ଥିଲି। ଏହି ସମୟରେ ମୋ ଦୋକାନରୁ ଝୁମକି ପାଟିଆ ଗ୍ରାମର ଧନେଶ୍ୱର ମୁର୍ମୁ ରିପ୍ରେଜେଣ୍ଟେସନ, ଯାହାକୁ ମୁଁ ଆଗରୁ ଚିହ୍ନିଛି, ସେ ମୋ ଦୋକାନକୁ ଆସିଲା, କିଛି ଗୁଟକା ନେଲା। ଏହାପରେ ମହାବୀର ପୋଷି ଗ୍ରାମର ରବୀନ୍ଦ୍ର ହେମର କୋ ଆଗୁଛି, ଯାହାକୁ ମୁଁ ଆଗରୁ ଚିହ୍ନିଛି, ସିଏ ରାସୋଳ ଛକରେ ଆସି ପହଞ୍ଚିଲା। ତାପରେ ଧନେଶ୍ୱର ମୁର୍ମୁ ଓ ରବି ହେମ୍ବ୍ରମ ମୋ ଦୋକାନଠୁ ଟିକିଏ ଆଗକୁ ଯାଇ କଣ କଥା ହେଲେ ମୁଁ ଶୁଣିପାରିଲି ନାହିଁ। ଏହାର 10-15 ଦିନ ପରେ ସେ ଦୁଇ ଜଣ ରାସ୍ତାରେ ଆଗକୁ ପଳାଇଲେ। ଏହାପରେ ମୁଁ ଶୁଣିବାକୁ ପାଇଲି ଯେ ଧନେଶ୍ୱର ମୁର୍ମୁ ରବୀନ୍ଦ୍ର ହେମ ମିଶି।
What will you get out of
that is one thing, my lord. Thereafter, my lord, one Rama Marandi, my lord. Rama Marandi what stated, my lord, is evidence, my lord. Relevant person I am read out. No. Dhaneswar Murmu.
Rama Marandi is a witness who is present in the police station before whom the both of them confessed.
And Ponchu Marandi.
ସେ କହୁଛି ମୁଁ ଆଜି ବ୍ରାହ୍ମଣୀପାଳ ବଜାରରେ ଥିବା ବେଳେ ଆପଣଙ୍କ ଅନୁରୋଧ କ୍ରମେ ଥାନାକୁ ଆସିଲି ଏବଂ ଦୈତାରୀ ଥାନା PS କେସ୍ ନମ୍ବରରେ ମାନେ ଜବାନବନ୍ଦି ଦେଲା ବେଳକୁ ମୁଁ ଶୁଣିଲି।
How many witnesses you have?
There are.
My lord, charge sheet witness is 27.
What is the stage?
Trial start
not started, my lord. So in fact, my lord, there is a developmental case and the link, my lord, admittedly there is a quarrel between the petitioner and the deceased, my lord, regarding the land dispute, and also the one they are related to each other, my lord. They sold the.
But he says that it's not land dispute. Something.
There is there. Police while during investigation, my lord, supervised the case and found some materials that is in the case record, case diary, my lord. That is, my lord, that what happened in this case, my lord, the accused, this petitioner suspect that the deceased might be, my lord,
doing black magic.
Doing the black magic. For that reason, his father died. For that reason, he repose grudge on the deceased, my lord.
This is and conspired with Ravi and they
Ravi and
went.
complaint matter.
Achha, to पढ़िली
And
मैं.
link is my lord, link. The motive is very clear, my lord. Since then, my lord. And that happened in the meantime when the father's, my lord, Sudhikriya, the present accused sold one ox, my lord. And the petitioner also demanded money from him, as because there are 2 ox, my lord. And the deceased demanded money, give me 5,000, and he sold of rupees 10,000.
সেটা পড়লি বা?
And that is also the dispute, my lord, enmity. And enmity earlier, he doing the black magic, for that reason his father died. And that is, my lord, the motive, my lord, to commit murder. Then he hired the Ravi, and both of them committed murder. Link is that, my lord, on the night of the occurrence, I have read out one person, my lord, namely Krishnachandra Dowry.
He has seen them,
both
they
of
were
talking together, and on the a few hours, my lord, he came to know that they have been killed, my lord.
সন্ধ্যা 6টা বেলে তা পান দোকান পাখে
While they are in police custody, they confess they are guilty and lead the police and gave report the Tangi.
That's the only evidence appears to me.
that is the only matter.
The other evidences are very.
This is the linkage, very circumstances chain of
Where is the charge sheet? Have you filed?
Yes, my lord.
And tell me the stage of what do you call
matter.
Right.
कौन सा?
Trial point,
Trial start है ना?
That has not been started. So, yes.
File the copy of the charge sheet and evidences and all.
Enter record.
Enter record. Please see it next week. Good day, and you have to seek instruction. What is the stage? And who are the material witnesses? On the basis of this kind of evidence, I don't think you can convince.
Since the chain of circumstances has already been completed, for that reason, my lord, I have a case, my lord.
Let us
Otherwise,
see
I have no don't have case.
Who all are the material witnesses? Let us understand and we'll see what it is.
Arjun, next.
Next week रखियो. अगर item 70 भी. अगर item number मैं pre. Item number 70 already acquitted, my lord. Not press.
Not press because the accused has already been acquitted.
और 71 टा क्या 71 76 टे next week करो.
71 he is asking for
71 and 76 I pray for next week.
My lord, item 62. Pray for next week. 62.
62.
Yes, ma'am.
Bail matter, why are you asking time? Bail matter also you want
next week.
Next week is not sure. We will adjust it.
But 57 simply urgent, I will understand that.
But you place on record because nothing is there. Whatever you both of you read, nothing was there.
I will place on record the charge sheet and the.
So that
yes.
Is may be entitled for bail. Mr. Ragada, he may be entitled for bail because
I know.
If 27 is only there,
My learned friend knows it very well, my lord. But for the sake of opposing,
he is doing his job. He has to do his job perfectly. We'll see that.
He will supply the copy.
Please supply the copy so that in this contest it should not be there.
UD case record I am not received. Though the case everything received, my lord. For a UD case, my lord, the date not given. I finally
Mr. Raghunar, let counsel for the petitioner submits that person to the order dated 1/9/2023. The case record is not received in his office. It is the matter. Yes.
My lord, one thing I pray, my lord, on 14th date is fixed. On that date, the charge will be framed because I am coming against the order rejecting my discharge petition. Earlier, there was an order that in the event I will file application
Same order will continue.
for adjournment.
Same order will continue.
That your lordship may indicate
Yes,
that.
same order.
My lord.
Yes, next.
24. Well, I don't know, on behalf of, yes, I'm telling you. Any other.
What is this matter? Last date of hearing also, nobody appears for the petitioner.
Now he's in code number 1, so I. Now he's in code number 1, so I.
You have challenged the cognizance order, even the charge sheet is not filed. Last time a direction was given to you that you at least file the charge sheet. None appeared, still I passed that order. Keep it after 2 days, we'll see. Otherwise, this will, yes. Next.
29.
Yes.
Petitioner and the informant is brother and sister relationship. My lord, the Dadaji Bhumi. My lord, the petitioner, informant's father is taking shelter in the house of the present petitioner. And there is a several matrimonial dispute between the mother of the informant and her father, my lord. Since her father is taking shelter in my house, in her house, therefore the being misguided by her mother, my lord, she has lodged the affair, my lord.
What is the stage? Investigation is on.
My lord, in the meantime, the compromise is going on.
But still investigation is still on. Must be, because he has only filed the charge sheet, nothing, sorry, FIR, nothing is there.
My lord, since the compromise has been done between the parties.
Where from I get that you have compromised?
My lord.
Where from? The record, nothing is there.
Not after filing of the case, my lord, notice may be issued and.
I will not issue notice. You satisfy me first. Only.
My lord.
FIR is.
My lord, kindly see the FIR, my lord. ମୁଁ ଶୁଭଶ୍ରୀ ପଣ୍ଡା ବୟସ 22 ବର୍ଷ ପିତା ଅନିରୁଦ୍ଧ ପଣ୍ଡା
You tell me what is the stage of the investigation?
Investigation is
going on. How can I cross the
my lord, on the ground of compromise, my lord.
Compromise, there is nothing.
My lord, let a notice may be issued and
No. I will not be party to your compromise. If you have compromise, go and tell it to the police and they may stop it.
My lord, there belongs to one family, my lord.
That's right. I am not disputing that.
ମୋ ବାପା ଆଉ ମାଙ୍କର ମନମାଳିନ ଯୋଗୁ ମୋ ମା ମୋ ଭାଇଙ୍କୁ ଧରି ମାମୁଁ ଘରେ ରହି ଆସୁଛି। ମୁଁ ମୋର ବଡ଼ ମା ବଡ଼ ବାପା ଓ ବଡ଼ ବାପାଙ୍କ ସହ ରହି ଆସୁଛି।
I'll record that. The investigation prisoner invoked the jurisdiction of the court under section 482 CRPC seeking passing of the FIR. When counsel for the petitioner submits that the parties have settled the accused and the informants are the cousin brothers and sisters, and they have settled their dispute. Nothing is based on record to suggest the same. Therefore, at this stage, I am not giving the indulgence to the petitioner in the present petition. However, liberty is granted to the petitioner to produce document before the investigating officer regarding the factum of settlement. If such a document are filed before the investigating officer, the same shall be considered by him on its. They will verify the same and take necessary call. Yes. You give it to the IO that will settle. He can file a closure report. Okay. Yes.
37.
20?
37.
May I please, ma'am?
Yes.
Initially, it was a case under section 307 and subsequently wanted to convert to 302. I'll have a glance to the affair. That starts page 7.
Hmm.
The informant is the none other than the father of the deceased, madam. ମୁଁ ଯେ ବନାମ ପାତ୍ର ସଚେଞ୍ଚ ଏକ ଯେ ଗତ 3 ବାର 2000 ତାରିଖ ମୋ ପୁଅ ଯେ ଦିଲେଶ୍ୱର ପାତ୍ର ଗୋପାଳପୁର ଖେଳ ଦେଖି ଫେରିଲାଳୁ ହରିପୁର ଛକଟାରେ ଆଗୁ ଲୁଚିକି ରହିଥିବା ଆମ୍ବ ଗ୍ରାମର is not named, my lord, here. ମାନେ ଅସ୍ତ୍ର ଧରି
Charge sheet file. এবারে রাত্রি
Petitioner moved
302 or 307?
No, 307, it was initial 307, converted to
302,
302.
my lord. But in fact, his prayer for bail rejected by the trial court, my lord, at the time of investigation, my lord. Now the charge sheet has already, charge sheet has already been
You repeat it.
No, my name is not been, my name has also not been found in the affair. I'll have a glance to page 6.
When charge sheet is filed?
Charge sheet has been filed, my lord, after 4 months, my lord, I was in custody.
At the time when your bail plea was considered, that time only FIR was there.
Only affair was there.
Then
Only,
now
only affair was there and the case was already converted to 302. Not that it was not converted.
That's right, but charge sheet has now been filed.
My lord, that's
And
it.
on that basis, you repeat your bail plea in the court of first instance.
Nothing more will happen, my lord. 7 accept rejection. Nothing more
You
will
have to
happen.
go to the court of first instance after changing of circumstance.
No, I don't dispute that. My humble submission, my lord, my humble submission, my lord, it's pending with the court. And during pendency of the application, my lord, charge sheet has been submitted. Not that after that.
That's right, but
So-
still you should go so that get every day one.
My humble submission is, since admittedly during the pendency of the particular case, the affair was lost. After 10 days, it was converted to 302. I was arrested the prisoner was arrested, and subsequently he approached the honorable trial court, the planet trial court. It was rejected, and he has also approached the honorable court. And during pendency of this particular case, my case has been now and it is the duty of the state to produce the CD. They have failed to produce the CD, and it was not taken off. That's why there's been lingered. And in the meantime, charge sheet has been submitted. So the mere charge sheet, my lord, either filing this way or that way, it will not. Well, it's subject matter of conscience. That is my subject, commission subject to acceptance, my lord. And it's a case where absolutely no allegation. Had there been allegation that I was there, I was there, or I have added or abetted the crime in any manner, 7 except while allegations has come up, affair knows the affair has been lost by none other than the father, who is the best person. In the affair, my name is not there. Absolutely no, my name is not there. Madam, I check it from page 6. Other 5 persons were there, and it is also their case that they have, because of some reason, they have assaulted. Subsequently, when the 161 statement, when he is the expired, my lord, my name is added to the extent that after the occurrence was over, my lord, it is alleged that the petitioner has given them some money and allowed them to move away from the particular place. So at best, my lord, it will not also constitute offense under section 216, harboring criminal offenders, because they are not the offenders. But things even whatever it may be, it is there that I have assisted only after the occurrence was over, and that has also not been borne out from the affair. So this was the allegation, and with that I am in custody.
What are the injuries?
Injuries, my lord, only one injury, my lord. Postmortem report is clear. Only one injury on the.
Who has given that blow?
My lord, 5 persons, specifically 5. Those 5 persons who have been ending the affair. I was not there. I have not tossed, and this is the case. And external injury.
Is that the story in the charge sheet also?
Yes, my lord, charge sheet also.
Charge sheet, my lord, I read out, my lord. Though it is, my lord, they file hand out to my friend, but in fact, I am doing.
But I think you should go. I
record everything.
These
persons are having 3 other criminal, 307 other criminal.
I don't
cases,
dispute
my
that.
lord.
There is
are
no
assisted
similar
there,
case.
my lord.
No similar case. No 302, nothing is
307
there.
is there.
Oh, yes. I'm
307
not
is there.
disputing. I'm not saying that I'm a good man.
But
But things even so far the allegation about the case is concerned, it has been developed in the affair. 5 persons are specifically named, and so all the witnesses category stay. They are the eyewitness to the occurrence. My name was not there.
Where is the charge sheet? Where is the charge sheet?
Charge sheet was submitted, my lord.
On
4/4/2024.
No, no.
4/4.
Oh, December.
Yes, on 4/4.
December 23, it was rejected. You go to trial court.
On 4/4, my lord. My lord, I will bear me, my lord. I going out to particular court only for the purpose of charge sheet, my lord. Not, my lord, proper. My humble submission, because I say it's a case.
It is the only proper thing. Court of first instance should look into it.
No, court of first instance, well, definitely, my lord, he has rejected my application. Absolutely, the moment.
Now he'll give the bail. I'll record everything.
No,
whatever you are saying.
my lord, if that is so, my lord, may to keep it as a case, my lord. I'm not saying no, because if this will be the order, I have no other way to accept.
No, that's right. Ideally,
But
you go to the court of first
merely
instance.
because, merely because.
Suppose, for example, I'll consider it rejected. What is the option? You have to go to Supreme Court only.
Yes.
So better that you go try your luck and come here again.
No, where there is no allegation, that's why we are in.
No, I'm just imagining a situation.
Please,
This
I don't
may also
know.
happen.
Lord,
You are not sure about it.
my lord,
Why to
no,
go
my
to
lord
court of
knows-
first instance, try your luck?
my lord,
Does it happen then?
No, I am not saying that. Day in and day out, my lord, we are here. And we are also accepting some order will be, my lord, say going back, go at bats just like a tennis ball, my lord, we are going to there, my lord. But here's a case where I can out a case, or I think it's a
Now
case.
you've got a new tennis ball. That's what I'm saying. Charge sheet.
No, charge sheet.
At the time of FIR, you went.
No, rather.
And December
rather-
2023, it is rejected.
My lord,
Thereafter,
rather-
in April, charge sheet is
my
filed.
humble submission, rather by filing the charge sheet, my lord, you rather strengthen my case to the extent my.
I know your case is now
Yes,
strengthened.
my complicity was there and they can move to any extent, my lord. Now when the charge sheet has been submitted, my complicity ends to a particular.
That time your role was suspecting.
Yes.
Thereafter, after investigation, something has come out.
Come up.
There
And
is
now there
nothing
is
against you.
Yes.
Nothing against you.
And my
Your
lord,
case is rather strengthened now.
my lord,
So
obliged.
therefore, in that situation, you should
So
go.
my humble submission, so doing this, if I lord again send it to my lord to
Then place on record the charge sheet and all.
Yes,
What the difficulty I'll tell you. I call for the CD.
My lord.
You read out your portion, he reads out his portion.
Right, my lord.
There is nothing on record.
I will file. I will file by tomorrow, my lord. I will file.
While giving dictation and nothing is there.
Obliged, my lord. I will file. That is my mistake.
So
I
that's
took
the
on-
whole difficulty.
Yes, yes. I will file by tomorrow. I will
So
file.
if you go to trial court, everything is there with him
Okay.
on record. He'll
All
take
is
this.
okay. We have the. I am not saying. I have not. I will not. go.
Anyway, if you want to argue, let it be. Please.
I'll file tomorrow. I'll take it on Friday.
He will give it.
Friday. दे दो.
Give it. दे दो. Adjust कर.
Next Monday, Florida Council.
See, the board has to be manageable.
Yes,
That's the whole. Sometimes it is getting
No,
so
my lord, with
unmanageable.
all respect, my lord, in some cases we are, my lord, insisting upon, we are praying for a constitution.
I'll hear it. We will adjust a date and give. Yes. Next.
I may pardon, my lord. Item 59, till that letter, no procedure. I will file the document before the IO, and till that letter, no procedure.
You are on custody, in the custody.
My custody, Bahrain.
Was it an anticipatory bail?
No. 29, my lord. Item.
Passing. Nothing will happen, you go on. Yes, next.
58.
My made legal notice. The present petitioner has been falsely implicated in the case under section 376D, 394, 34 IPC, 6 Foxtrot. The lottery has last occasion directed the government advocate.
I have received the case diary, but in fact, I don't know. Since offense 370D is there, my lord, notice will go to the informant, my lord. Notice.
Informant is there.
She will file the requisite matter.
She has not implemented.
She has to implicate, my lord. 370D is there.
Either about 4 years, he is in the custody.
370D is the notice to informant.
4 years she is in custody. 4 years. So why don't you implicate the informant?
370D is there. For that, my lord, notice will go, my lord. Otherwise, my lord can dispose for that.
Since the allegation against the petitioner is regarding the offense under section which are
370D.
and other
offenses, my lord. 363, 294, 394, 506, section 6 of the POX Act.
And 376D also. The petitioner takes time to implead the informant prosecutrix. 1 week time is granted. List the matter. Implead and file MRD parties.
Within 1 week, I will.
59.
Yes.
Petitioner is in custody since 2023, 11 to the 23, my lord. In this case, FR was registered under section 3762M, 411, 417, 403, 324 of IPC.
Sir, you have not filed anything, even FIR is not filed.
FR was not with my position.
Only the order of rejection and bail.
Last occasion, charge sheet has been submitted. We also called for. The last occasion is also ascertained that one sister statement has not been received by the council for the state.
Do you have 160? What is that?
Both are the consenting party, my lord. Both
More than a Vivahita Mara.
100%.
Possible, wait, you have filed an incomplete petition, you have not given anything.
Pardon.
I'm trying to help you out. Wait.
ମୁଁ ଜଣେ ବିବାହିତ ମହିଳା ମୋ ସ୍ୱାମୀ ମୋତେ ବହୁତ ବାଡାପିଟା କରିବାରୁ ମୁଁ ତାଙ୍କୁ
Subsequently, she came to know that some unknown person.
One minute.
One. My lord, there are 3 cases, my lord. 60, 61, my lord, 1 and a sub-item 61, my lord. All the three cases, my lord, today morning I have received the case diary, my lord. Can I take on day after?
1 week, 1 week. All these 60 and 61. Yes. Next.
Yes, 61, two cases, my lord.
1 week.
62 cases and 61 cases.
Yes. 61.
Yeah,
61.
let's see, posted it to, I think 60, 60 and next week. Obliged debtors.
63. 63, yeah. 62. 63.
63, your lordship, I'm praying for a short adjournment because in the meantime, as per my instruction, the victim has already been examined. I have sought for her deposition. Let it be taken up next week,
Then
any day.
1 minute. If the victim
Ma'am.
has already been examined, you go to trial court once again. Repeat your plea.
My lord, in fact,
Petitioner is agreed by the order dated 8/12/2023, whereby his bail plea has been rejected by the court below. He is accused in first paragraph, second paragraph, during the during the currency of the trial. Material witnesses, including the victim in the present case, has already been examined. Therefore, the petitioner, therefore, I'm not inclined to entertain this petitioner at this stage as it is, however, giving a liberty to the petitioner to move press waiting from the trial court on the changing circumstances. If such application is moved, the trial court shall consider the same on the basis of available material or what is for. Yes, next 64.
64.
May I please, your lordship? My lord, petitioner is in custody since 30th November 2024. In fact, remanded in this case. He has been arrested on 23rd of November 2023 in connection with a case under section 399/402 of IPC. And the present case is of in the year 2022, your lordship, under section 394. It was registered against two unknown persons. And the petitioner, when arrested in connection with another case, thereafter he has been remanded in the present case. Allegation is that the informant alleged that two unknown persons being masked came and restrained his vehicle and snatched away 72,000 along with one gold chain, my lord. Thereafter, the present petitioner is arrested and remanded to jail custody and remanded in the present case. It is alleged by the during investigation, it is ascertained that the co-accused person stated that the present petitioner, along with other two co-accused persons who confessed before the police, that this petitioner was with them at that time committing that crime. Charge sheet submitted against 3 persons, though FR was registered against 2 persons. Charge sheet has been submitted against 3 persons on 24/1/2024, your lordship.
Including you?
Including myself.
You are in custody since?
I am custody remanded in this case on 30th of November 2023, your lordship.
How many cases you have?
My lord, ନାଇଁ ସେଇ ଯୋଉଟା ରିଜେକ୍ସନ ଅର୍ଡର ଲେଖିଛନ୍ତି ସେଥିରେ ଆଜ୍ଞା ସେଗୁଡା somehow typographical mistake is there because in the main case in which I was arrested, I got bail from this honorable court, and at that time my state counsel who was opposing in that time, he was stated that I have 3 cases except that, including this present case, but that numbers are not there in which is present in the rejection order, my lord.
But there are 3 cases.
My lord, my lord.
Forget about numbers.
My lord. 3 cases, all are prior to that, my lord, and registered.
You are on bail in all the cases.
No, my lord, I have not been remanded in 2 cases, my lord.
So
I have arrested in 1 case and remanded in the present case, my lord. I have not remanded also in other two cases.
Once I'll give the bail and you will be remanded in that case.
Yes.
That might be.
They are waiting for that.
That might be, my lord.
They are waiting.
Self nature.
Why he is in custody? You tell me one thing. Somebody is in custody, in your custody.
Yes.
You know that there are 3 cases. Why are you not taking them in remand? For what good reason?
He's about 8 months in custody.
For what good reason? So 5 cases he is involved in 5 cases. You know that.
Yes.
Cases are known to you. He is in custody. In one case, you will take remand. He will struggle and get the bail. The day he got the bail, next day you will remand in another case. Then he will struggle for another couple of months or couple of years. He get the bail, again you arrest him. What is this?
My lord, the main case in which he has been arrested, he has been
This
released since February.
This is completely abuse of the powers. 3 cases are there, you take remand, you do hang him. But you can't installmentally keep on. He is in your custody. It is your responsibility that you prosecute him. You tell me which are the cases where you have not been taken into custody and seek instruction. When are you remanding him in those cases?
My officer received this copy 3 years.
See what these people are doing, I'll tell you. These are the noted criminals of that area.
Yes.
Cases are there, 5-6 cases are there.
Habitual offender.
And the police wants that they should be in the custody. Once they'll remand in all the matter, they will get the bail. Then they'll create problem. So therefore, this technique they utilize. That you know and everybody knows.
Yes.
But this is against law. This is against law. You just seek instruction. Why are you not remanding them in other cases? And when are you going to remand? Because he get the bail here also, he will remain in the custody. That's the problem. Let him get the instruction. I'll take it next week. Huh? Next week, 1 week up.
My lord,
I'm not writing this because this is not the job of the court to ask you whether you should take remand or not take remand. I'm just orally telling you.
Yes.
Take instruction. I'm not going to write anything.
Taking detailed instruction.
Yes.
Yes.
But discourage them to practice this kind of thing.
Yes.
Your lordship, I am filing a copy of the affidavit which was filed in the earlier case, my lord, and I am serving a copy also.
Don't open it now. Don't open it.
Because they have submitted for that reason.
Don't open in the sense, don't file here.
I am serving a copy.
Send the copy and file it. Simply at the end of 1 week. Give it. Don't take it. Where will you keep it? Don't take it. You file everything. We don't have any file here. Take the Wakalatnama also. Who has given that?
My lord, because the case was...
Whatever, because you file it.
Yes, your lordship.
Take it.
My officer received the copy only by the last Saturday.
Oh, it's all right.
Yes.
1 week up.
Yes.
1 week up. Yes.
65. My lord, I will pardon, my lord, I did not file the postal requisite due to my fault, my lord, for issuance of notice. Your lord,
65.
my lord, your lordship may grant 3 days time, I will file.
1 week up. 1 week up. But
Fine.
do it.
Well-
Bail matter, do it. Don't waste time. Okay.
66.
Do it with 3 weeks, 2 days. Huh?
My lord.
Yes. Yes.
66.
May I pray?
Yes, sir.
If I allowed under section 449, 302, 34 IPC, read with section 25, 27 Arms Act. The charge sheet was filed under section 449, 302, 212, and 34 IPC.
When the charge sheet filed?
Kindly see the FIR.
Charge sheet, when the charge sheet is filed?
Charge sheet filed, already filed.
When?
On 17/1/2024. 24. I have already filed the copy of the charge sheet.
Yes. No, it's fine report is that, yes.
Kindly see the FIR. I'm reading the
Come to the charge sheet straight away.
charge sheet.
Come to the charge sheet. What are the
Witnesses.
allegations against?
40 witnesses.
Hmm?
Case has been committed to the Court of Sessions.
40 numbers.
What are the allegations against you, sir?
And
Rakesh Pradhan.
the
What is
present person has not murdered any person. He was only allegation against him that in order to avoid the police arrest, he was taking them to Bangalore. And on the way, near Yelahanka station, they were all
Sorry,
arrested.
this petitioner is the elder brother of the men accused, both of those, both are who was fired and.
What
they
is
tried-
his role?
Yes, madam. And this petitioner.
Harboring.
Well,
Not harboring.
no, this petitioner having with 7 criminal antecedents along with his brother. And he has given shelter at the Lingaraj PS case under, and then they have tried to flee from here to evade the police arrest. And they all were arrested at the Miller.
He's the elder brother. of the-
Wherever, what is his role in this case, you tell me?
Giving shelter Miller and
Giving shelter only.
Only
He-
shelter.
He's not the main accused.
in this case, he is not main accused, Miller.
So then, oh, he may be. How many cases are there against him?
Madam?
Antecedents?
Antecedent Miller 7 numbers.
7.
Miller.
All are 302 and
No,
all.
no,
Then
no, Miller. Under 307, 9B Exclusive Act, and 363, and another case 379, 399, 402, and another case is 457, 380, and 379, 379. Habitual theft Miller.
custody since? Custody?
Madam?
Custody.
Accused.
These are the other case, Miller.
Is in custody since 13/8 to 2023. About 1 year.
Show me from the charge sheet. where it
Charge
is.
sheet already filed on 17/1.
I know charge sheet is filed. How many times you will tell me? Show me relevant part.
Yes, madam. I'm showing the statement of the Prashant Kumar Sasmal. ଆମେ ଦୁର୍ଗ ସଂଗ୍ରାମ ଭୋଇ, ତପନ ଭୋଇ, ଜଗନ ଭୋଇ ଓ ତାର ଭାଇ ରାକେଶକୁ ପ୍ରଶାନ୍ତି ଏକ୍ସପ୍ରେସର ପଛପଟ ଦ୍ୱିତୀୟ ନମ୍ବର ଜେନେରାଲ ବଗିରୁ ଧରିବାରେ ସକ୍ଷମ ହୋଇଥିଲୁ। ମାନେ ନିୟର ଲେହେଙ୍କା ଷ୍ଟେସନ ହି ୱାଜ ଆରେଷ୍ଟେଡ only in order to avoid the police arrest of his brother, younger brother. He was taking them to Bangalore.
In Prasad Express.
And also statement of the Sunil Yadav. He has also stated that.
How many accused persons are there?
3 accused persons. The main accused person, Jagan, and who? He is the elder brother. Rakesh is the elder brother of the Jagan. Also statement of the Jagannath Prasad Behera. He has also stated. राकेश प्रधान हमको नहीं होता बैंगलोर भी नहीं होता सेटा द स्टेटमेंट रे
Yes, anything is there?
This is only the railway. I may read the relevant part of my Lord 161 statement. Railway inquiry to Jana Padla, Jagana Pradhan, Sangram Boy, Rakesh Pradhan, this petitioner. Number of consi bought the reservation of it. Semana local वगैरह
Do you leave those you in the
Yes.
in the offense of 302? What is his role? I am asking.
No.
None of you are able to tell me.
No, my Lord.
Show me which part, how he was killed.
No, my Lord. Only he has given shelter and tried to evade from the police arrest. So these men accused persons.
I'll grant him leave. Grant him leave. I'm granting him bail. Because there is no
Case has been committed and in the is now
You are
pending.
not able to tell me anything. I'll have to read and pass the order.
67.
ये hard copy अच्छी नहीं you give it or how will I give dictation? No assistance from me. Huh? Yes.
67.
May it please your Lordship. Lordship, the present petitioner, number 1 and 2, Your Lordship, they are in custody since 8/8/2023, Your Lordship. The present petitioner number 4 is in custody since 17/8/2023, Your Lordship. 8/2023, Your Lordship.
First one.
First one is at 8/8/2023. First 3 petitioners. And the petitioner number 4 is from 17/8/2023.
This is 4.
Yes, Your Lordship.
How many?
4 petitioners are there, Your Lordship.
1 8/8 or 2
8/8, Your
17/8.
Lordship. No, Your Lordship. 1, 2, 3 are of 8/8.
Okay.
And 4 is from 17/8/2023, Your Lordship.
ठीक है.
Your Lordship, initially FIR was registered under section 302 and 34 IPC, Your Lordship. Subsequently, charge sheet has also been submitted under section 302 along with other allied offences, Your Lordship. Allegation against us is that while other petitioners have assaulted the deceased, Your Lordship, resulting in his death, we were only present at the spot, Your Lordship. Apparently, this is a matter between 2 families pertaining to herding of cows, Your Lordship. If I may take Your Lordship to page number 10, that is the FIR, Your Lordship.
CD is there with you? Are you ready? Yes.
Your Lordship, the informant says, Periba Rastare, Ranjan Deuri, one of the accused person, Pita Vaishnav Deuri, O Bandhua Pradhan, another accused person.
Yes.
ଉଭୟଙ୍କ ଘର ଆମ ଘର ପାଖରେ 2 ଜଣ ମିଶି ଟାଙ୍ଗିଆ ଓ ବାଡ଼ିରେ ମୋ ଶ୍ୱଶୁରଙ୍କ ମୁଣ୍ଡ ଓ ଶରୀରରେ ବିଭିନ୍ନ ସ୍ଥାନରେ ଆକ୍ରମଣ କରି ଜୀବନରେ ମାରି ତାଙ୍କ ପାଖରେ ଥିବା ପାଣି ଡ୍ରେନରେ ଫିଙ୍ଗି ଦେଇଛନ୍ତି, Your Lordship. Subsequently, in the
names,
Your Lordship, the names is Ranjan Deuri and Bandhua Pradhan. They are not the petitioners in this present application, Your Lordship. Subsequently, in the 161 statement, she has stated that Samaste Misiki Marichante.
Okay.
In this statement, 164.
Yes, 164 has been subsequently reported.
This brutal murder case matter in front of the complainant and regarding
Is the informant himself.
the wife of deceased also. And both have
there are 2 eyewitnesses.
There are 2 eyewitnesses. One is the wife and other is the mother.
The Pradhan Mayor, and according to the 27 evidence at Mayor leading to discover the weapons also Mayor.
What is the stage of the trial?
Mayor.
Stage of the trial.
Trial has not commenced, Your Lordship. Your Lordship, taking into account the recovery statement of that Gopa Pradhan, Your Lordship, who is one of the petitioners in the present case.
But in 164,
they have not.
Witnesses have taken you on.
Yes, Your Lordship. Witnesses have not stated our name. The overt act has not been attributed to these present petitioners. That is my whole contention, Your Lordship. And the case of brutal murder, Your Lordship may look into the injuries. The injuries are abrasion injuries and laceration injuries. And even if there are certain injuries those are not attributable to us, only because we happen to be the family members.
Anything is attributed to them?
My Lord, I did only 4
Yes.
My Lord, 7-8 तेज दिन मो मामू तुलसीदार एवं बेले नुआ गुरु आम पुराना गुरु को आसीतला बेले से दिन संध्या 5टा बेले को मो एवं मोर सासु ओ ससुर समस्त मिसे आम नुआ गुरु को जाउथि आम पुराना गुरु बाहर किछि बाट गला परे बाटरे हठात रंजन देउरी बंधुआ प्रधान गोप प्रधान दिस पिटिशनर पूर्ण देहुरी शरत देहुरी दिस पिटिशनर एवं
ललिता देव
मिसी करी आसी हेंगारे मोर ससुर शंभु बेरा को माड़ मारिले एवं पत्थर रे छेची करी तांको साइकिल रे थिबा टांगिया को नै तांग आखि रे हानि देले जा फल रे सेही घटना स्थल मरि गले मु एवं मोर सासु जे प्रतिवाद कलु से हमको जीवन रो मारि दा पई
And also another one statement also corrupted the same, and that the white was deceived. And in another case, my lord.
What are the antecedents of these people?
No antecedents, Your Lordship. Family dispute, Your Lordship. Also, the fact that he says that we have stabbed, the other petitioners have stabbed him by stone, Your Lordship. There is no such injuries to that
Charge has
effect.
been framed, huh?
No, Your Lordship. That has not been framed, Your Lordship. Our only contention is, even if we are, Your Lordship, aggrieved of something, we have a role in 201 at best, Your Lordship. Because in the FIR, she is clearly stated.
164,
Your Lordship, 164, even if she's saying that everyone was there, Your Lordship. Participated, Your Lordship. There has to be injury to that effect, Your Lordship. There are injuries pertaining to that Ranjan Dowry and another person. Those injuries are there, Your Lordship.
medical evidence. What is medical evidence? What are the corresponding injuries?
All the above findings were antemortem in nature. Cause of death is due to.
How many injuries?
Your Lordship, 12 number of injuries are there. All are
injuries and
all
2%.
abrasion injuries.
2% can't cause 12 injuries.
Your Lordship,
And all of you were there. 164.
yes, Your Lordship. I admit that I was there.
Wait till the eyewitnesses are examined.
Yes.
Eyewitnesses are examined or 6 months, whichever is earlier.
Your Lordship, may the eyewitnesses are examined.
Whichever is earlier.
Yes, Your Lordship.
Whichever is. The petitioner is agreed by the order dated 6/11/2023, whereby whereby their bail applications have been rejected. Or counsel for the petitioner submits that although in the FIR no overtake is attributed to these petitioners except overtake the allegations are only against Ranjan and
Dowry.
Dowry. However, after investigation, charges have been filed against all the accused persons. In the statement under 164 CRPC, the eyewitnesses have named the petitioners along with Ranjan and Dowry. The deceased has received multiple injuries. Therefore, I am not inclined to entertain the bail application at this stage. However, liberty is granted to the petitioner to renew the bail plea after the eyewitnesses are examined. The trial court is directed to give preference to the trial court is directed to preferentially record the statement of the eyewitnesses instead of recording evidence of formal witnesses. If the eyewitnesses could not be examined within 6 months, the petitioners can renew their bail plea after 6 months. After 6 months. With this observation, the petition is dismissed.
Much obliged.
68.
On behalf of the conducting counsel, may I pray for a short adjournment? He has some difficulty.
Adjourn. Yes. Next.
69.
We have
May I
next week
please-
the morning. Yes.
May I please, Your Lordship?
Yes.
My Lord, offense under section 302, basing upon the circumstance, evidence petitioner has been taken into custody. The deceased is the wife of the petitioner, my Lord. And my Lord, have a glance to page number 27.
What is your case?
My Lord, the petitioner and deceased deceased is the wife of the petitioner. They have some quarrel, and between that quarrel, petitioner has assaulted the deceased, and the deceased has been.
What is circumstances? You have
Sir.
assaulted.
My Lord, the
You have created the
they are no
ground and thereafter you assaulted. You kill. What is the circumstance?
They are
And
no
the circumstances speak the truth,
they are
not the
no
witnesses.
direct eyewitness, my Lord. Actually, the
May
all
not
are
be-
the post
In every case, you may not get direct eyewitness.
they are post occurrence witness. To page number 27, my Lord.
How many accused persons are there?
One, only husband.
Your husband. You are in custody since?
Since 8/7/2023.
8/7?
2023.
23.
My Lord.
About 1 year. What did this say?
And the charge sheet has been submitted, my lord. 1/30, my lord. We have to try to start.
Any eyewitness?
No, man. Eyewitness is there, my lord.
Who is there?
Neighbor.
Yes, I seen it.
Yes.
There, my lord, post occurrence. Post occurrence. Page number 27, my lord.
My lead only 4 legs, my lord. My lord, ତାର ସ୍ତ୍ରୀ କୌଣସି କାରଣରୁ ଘରେ ରୋଷେଇ କରୁନଥିବା ଯୋଗୁଁ ତାକୁ ଖାଇବାକୁ ଦେଲାନି, ତେଣୁ ପୂର୍ଣ୍ଣ ପ୍ରଧାନ ତା ସ୍ତ୍ରୀ ଉପରେ ଭୀଷଣ ରାଗି ତାକୁ ପିଟାମରା କଲା। ପୁଣି ତାର କାମକୁ ପଳେଇଲା। ପୁଣି ପ୍ରାୟ ଉପରବେଳା 4 ଘଣ୍ଟା ବେଳେ ଘରକୁ ଆସି ତା ସ୍ତ୍ରୀ ସହିତ ଭୀଷଣ ପାଟିତୁଣ୍ଡ କଲା। ଗୋଟିଏ କୋଡ଼ିରେ ତାର ସ୍ତ୍ରୀକୁ ପିଟିବାରୁ ସେ ମାଡ଼ ଖାଇ ଅଚେତ ହୋଇ ତଳେ ପଡ଼ିଲା। ତାଙ୍କର ପାଟି ଶୁଣି ସେମାନଙ୍କୁ ବୁଝାସୁଝା କରିବା ପାଇଁ ଆମ ସାହିର କେତେକ ଲୋକଙ୍କ ସହିତ ତାଙ୍କ ଘରକୁ ଯିବା ପାଇଁ ବାହାରିଲା ବେଳକୁ ପୂର୍ଣ୍ଣ ଆମକୁ ଦେଖି କହିଲା ମୋ ଘରକୁ ଯିଏ ଆସିବ ତାକୁ ପ୍ରାଣରେ ମାରିଦେବି। ତେଣୁ ତାର ରାଗ ଦେଖି ଆମେ ତା ଘରକୁ ଗଲୁ ନାହିଁ। କିଛି ସମୟ ପରେ ସେ ଘରୁ ବାହାରି ପଳେଇଗଲା। ତାପରେ ଆମେ
Material witness. Oh, eyewitness examined. Right. After the material witness is examined, the petitioner can revive his bail plea. Next, please. Next.
72.
72, my lord, praying for adjournment.
Why you have taken a contract of
No,
asking
my
for
lord,
adjournment?
actually, he was there.
You
in
have,
the
just now you asked in one matter.
It's the same conducting counsel. He has some difficulty. So he has.
Well, you tell me
requested-
what is this matter?
My lord,
Don't
I-
accept this brief without file asking for adjournment.
But I
What
have
is this
not
matter?
gone through it.
71.
Yes.
72.
Because if I'll adjourn for a longer day. Therefore I'm saying your client is in custody. He will suffer. What is the case? He is entitled to bail, then we'll consider. Otherwise, you'll adjourn.
My lord, just a minute, because earlier, before long, my lord.
He was there. In the,
Let us see. Let us see if he is entitled to bail. It is a 302 case.
at 302-201, my lord.
Any direct allegation? It is there with you?
Yes, ma'am.
Yes.
It's a heinous crime, my lord, and this petitioner has been with 4 criminal indictments. My lord, according to the contestant statement, my lord, they leading to disclose the opener seats and
My lord, I am not the prime accused.
Allegations are serious.
27 discovery is not completed, my lord, because the chemical test has not been completed
The
yet.
report is awaited.
My lord,
When the charge sheet was filed?
Case 28/8/2023, my lord. Perhaps that trial has not been started.
trial has not been started.
You would wait till the material witnesses are again.
My lord.
Wait till material witnesses are again. Then would forward this one. Yes. Next.
75.
My lord, in this case, last date honorable court directed to detailed instruction. The
Nothing.
main grievance of the case, my lord.
There is no direction at the request urgent, at the request urgent.
It was 75.
No direction was this. Yes.
75. It is 75. Yes. Today, I have taken instruction that today that final report was submitted.
Today?
My lord, today final report was submitted that this is a case of false case.
Then
So
you-
on merit,
apply.
Lordship may dispose of that.
Apply, you have to-
Disposal.
Right.
ମୁଁ ତ ମୂଳରୁ କହୁଥିଲି this is a false case.
Right, but order dated, is it- when your bail application was rejected in the prayer, you don't write it.
ନାଇଁ ମୁଁ ବେଲ୍ ମୁଭ୍ ହେଇନଥିଲି କିଛି।
Oh, what is this matter?
Rule
94,506 to quash the FIR.
Acha, for quashing the FIR.
FIR. Police already submitted, this is a false case.
False case, you, every accused will say false case only.
Because my lord,
Charge
the
is required.
brother my
The
lord,
petitioner is in-
that the age at about to 85 years.
CRPC seeking quashing of the FIR. The investigation was going on during the pendency of the present petition. Learned Counsel for the state submits that today the final report under section 173 CRPC has been filed. Therefore, the Learned Counsel for the petitioner seeks to withdraw this petition to avail his remedy under law
ଆମର remedy କିଛି ଦରକାର ନାହିଁ, case ତ false ହେଲା, ଆମେ
after perusing the charge sheet. With this observation, the police will dismiss. Next.
77.
Obliged.
This notice is issued to the informant, your lordship, but as per the endorsement, there is no endorsement of reason of the on delivery of the
Yes.
notice, your lordship.
Service complete.
There is no endorsement, your lordship.
Without any postal endorsement.
Rest it.
Yes, your lordship.
Rest it.
But the address is same as on the mentioned in the FIR, lordship.
What are
This
the
is
offenses?
this is for quashing of FIR. That is 2021, FIR was registered. In the meantime, charge sheet was submitted. Both the two cases were lost, my lord.
Yes.
One is, my lord, on 10/10/2021. Another is on 26/4/2022. Two cases are there. Two cases, a charge sheet was already submitted.
Two case who filed against whom?
My lord, against the husband and in-laws, my lord. In first case, my lord, 492A and other offenses is there. When she has gone to the police station, at that time, the petitioner and his in-laws, my lord, they have threatened the informant. For that reason, another case was registered.
Subsequent FIR is there.
Charge sheet is filed.
Charge sheet in both the cases, charge sheet has already been submitted. So why the FIR will be quashed in the meantime?
Instruction in the regarding the present status of the trial, your lordship. I have to obtain instruction, or otherwise I will please to take another.
Fresh steps to serve. The petitioner is directed to take fresh steps to serve opposite party number 2. Please the matter of case.
Okay.
3 matters, huh?
Yes, your lordship. Sub items are same.
All of they are accused person. They are seeking
Yes, your
quashing.
father-in-law, husband.
You serve through IU also, if she can be served.
My lord,
we'll send it for mediation.
Yes, ma'am.
Family.
It will be better.
family-
Better.
family-
It will be better. Yes, ma'am.
Yes, sir.
The counsel for the state is also directed to inform regarding the pendency of this matter to the informant, that is opposite party number 2.
Yes.
You just inform.
My lord, all the three connected matters, my lord.
नहीं परे करियो ना मेडिसिन फर्स्ट आसले पर मेडिसिन
78.
Maybe, lordship. Notice issued to the OP number 2, return on delivered, my lord. And fresh notice, my lord.
What is this case? Quashing?
No, my lord. Only early disposal of 127 CRPC petition filed by the petitioner, my lord. The background of the case that, my lord, while anticipatory bail was allowed in favor of the present petitioner, there is a condition to pay maintenance to the wife and his children, my lord. In the meantime, wife married.
Then service is required. She has to come.
Yes, ma'am.
Maintenance.
Reputed within a week, my lord. Fresh address to be obtained.
Address, fresh address you want?
Yes, yes, ma'am.
Learned counsel for the petitioner seeks 1 week time to file the fresh addresses of opposite parties. Let him do so within 1 week. After after furnishing fresh addresses, necessary steps may be taken by the petitioner to serve the opposite party. Yes.
79.
Yes.
79, my lord, he has challenged the cognizance.
Cognizance.
My lord, 7/9/2023 order. Offense 465, 467, 468, 471. That a petitioner has taken signature from the real landowner. Though that land was earlier sold by the, purchased by the informants father. Mutation was not made. In the meantime, this present petitioner has taken another registered deed was made from the real owner.
Charge sheet, cognizance, huh? Charge has been
That's
framed?
my charge sheet is submitted, cognizance taken.
Charge has been framed?
This first time it has come that I have not obtained any instruction.
Friday? Monday?
Monday.
You seek instruction over charge has been framed.
Right.
Okay.
Item 18.
Land council for the state to non-appease for the petitioner, Taragata. Non-appease for the petitioner, land council for the state to seek instruction regarding the present status of the case. Yes.
Item 80, 81 and 82. Can take me district.
What are these matters?
Madam, 80 first item, my lord. That is for quashing of affair. Offense is 307, 386, 387, 506. But my lord, can you see the affair portion, my lord? The present petitioner is not named in the affair.
Investigation must be going on.
Investigation is going on. That
In
instruction-
both the cases, investigation are going on. Let the investigation be over. Your name is not there. Why are you coming to the court? Inviting problem for yourself.
Mr. Das is arguing this case.
See, in the FIR, your name is not there.
My lord,
Investigation is going on. You are coming for custody.
Can you take me next week, Mr. Das?
Are you requesting the police to make you an accused? This is the kind of petition you are filing. You are nowhere in the picture. You
My
file
lord-
a petition for quashing of the FIR.
My lord, 3 persons are there. Santosh Kumar,
I
Chabir
might
Panda,
understand it.
and Alok. Santosh Chabir, they have already.
You withdraw. Don't invite problem for yourself. Withdraw. If the charge sheet is filed, you have an option to challenge that. If at all charge sheet is filed. I'll just see. Simply, I'll say that the investigation is going on. He wants to withdraw and to avail remedy under law. If the charge sheet is filed, then you file it.
Actually, my anticipatory bail was it was rejected. First or
And
second or
he has invited all kind of problems. Land counsel for the petitioner seeks to withdraw this petition to avail remedy after the charge sheet is filed if the cause of action survives.
81, 82 also.
81, 8.
83.
80, 82,
81,
81, 82. Yes, sir. Yes, Mr. Naik.
Let's see the very interesting case, let's see. The petitioner.
Even if it is not interesting, you will make it interesting.
Let's see, interesting part is.
He is interesting and will make his case so interesting now. Yes.
Interesting part, let's see, let me give the fact of the case. This lady, while she was eating during lunch hour, she saw some people have come with a vehicle to demolish his, started demolishing her boundary wall. Now she took the photograph that there are 2 police people along with one, and she immediately filed complaint before the police station. FIR was not registered. Thereafter, she came to this honorable court. Honorable court directed to register the FIR, and FIR was registered, but police did not arrest those 2 police as accused. They simply are made private party as a accused. Then we file a protest petition. Protest petition, the STJ held that since a sanction is required under 197, therefore you get the sanction order. Thereafter, I will make them the accused. Rejected the order. I impugn order. I also, my lord. Thereafter, I filed revision case that they were not in the official duty. they were did not have come with any authority, as because there was no FIR against me, no court order, no order by any authority. Therefore, they did not discharge the duty. Therefore, the sanction part is not required under the law. Now, the session judge rejected holding the same. You get the, since it is a revisional jurisdiction, you did not get the sanction order. Being a private person, I am being victimized. How could I get the sanction order? I am not the state.
Yes, sir. My lord, why the revisional court has rejected? Because it is an interlocutory order. So revision is not
final, making them party.
for that reason,
Cannot
revision
be
is
studied
not
in
maintainable because it is an interlocutory order. And my lord, kindly see the FIR, my lord. FIR was registered under section 294 and 506 against person, my lord, page 9. Accused is, my lord, one Manoj Kumar Chaudhary.
So show me the order of the
My lord, I am going through that.
magistrate,
My lord,
where he is refused to take cognizance
My lord.
against the.
my lord, kindly see that.
Yes.
Page 14, my lord.
You see, test is in the protest petition if allegations are there.
Lordship.
Allegations are there. And in 202, the statement allegations are there.
Lordship.
And then magistrate is no option, has to take cognizance.
Yes, madam. My lord, kindly see the against whom he has lodged FIR.
And I have
Against
filed
one
affidavit
Manoj Kumar.
stating the name
1 minute.
with photograph.
My lord, page 14, my lord, kindly see.
Page 40.
14, my lord.
1-4.
1-4.
That is
Against whom accused is Manoj Kumar Chaudhary, my lord.
14 is the FIR.
14 is the FIR, my lord. Then, my lord, FIR, only one accused. He has made allegation against accused Manoj Kumar Chaudhary, my lord. My lord. Then the
I will have to see the protest petition and I will
And
have
in
to
a
see the
protest-
statement under section 200.
my lord, in the protest he alleged against other accused, my lord, even including the police officer.
That's precise the point
Yes,
I am asking
exactly.
for.
Show me the protest petition.
Protest petition is, my lord, page 19, my
19, huh?
19.
Show me the allegations. Who all are these police officer?
My lord, one is the inspector of police.
1 and
Page 20. Para 2.
1 and 2. 1 and 2?
My lord, inspector of police 1, 2 is SI police, 3 is constable, 4 is constable, 5 is the accused against whom the first FIR was lodged. And my lord, 6 is the driver of that JCB machine.
And you have forgotten to include Home
Lordship,
Secretary,
kindly see the
and
photo.
Home Secretary, Home Minister and all.
Lordship, kindly see the photograph. I am
What SP and everybody you are
No, I am not against SP for implementing the order. No, I am against.
in a protest petition you are
No, Lordship, kindly see page 11, photograph. The police people who are standing there. Page 11.
See, he is raising a legal issue. Are you trying to find out the
Constable, Lordship, page 20, para 2, the name. Page 20, para 2, name I have given in the protest petition.
He is raising a very important question.
Lordship.
You have to answer that first.
Lordship.
He says that first you file an FIR.
Lordship.
The FIR you are not naming anyone. Investigation took place, final report filed. In the name of a protest petition, can you change your case? By bringing 1,000 people into...
Lordship, in the FIR, I did file the photograph.
Show me.
The page 11.
No, show me the FIR where you have whisper about these people. Simple whisper.
Lordship.
Show me.
Page 9.
Yes.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10 लाइन मु जेसीबी 10 लाइन पेज 9 एरिया रे लॉर्डशिप मु बेसी
जेसीबी चढ़ई
जेसीबी ओ पुलिस धरी आसुची तो घर खाली कर देली ए पुलिस मान को धरी के आस्ले इमीडिएट विथ दैट लॉर्डशिप आई हैव फाइल्ड द फोटोग्राफ दैट इज एट पेज 11
read completely. Let us understand what allegation.
मारी देला धमक देला एही समय आम
Have you made any allegation against
मनोज
these
आम
people?
घर परचू नहीं गला मु आज प्राय 1 वर्ष बोधे पढ़ी ओडियाटा तो पुलिस ना अछि भाई के पुलिस ना अछि
What? Where is that?
जेसीबी
If you have minor allegation also against police, in the protest petition you can very well improvise your case. No problem. But show me any allegation was there.
ଏଇଠି ଆଜ୍ଞା ଲେଖିଛି ଜେସିବି ଓ ପୋଲିସ କୁ ଧରିକି ଆସିଲା ମୁଁ ଫଟୋଗ୍ରାଫ ନେଲି ଆଜ୍ଞା ନା ନା ସାର୍ ଟିକେ ଶୁଣନ୍ତୁ ମୁଁ ଫଟୋଗ୍ରାଫ ନେଲି ଫଟୋଗ୍ରାଫ ରେ ଏଇ ଲୋକ ଏଇ ଘର ଭାଙ୍ଗୁଛନ୍ତି ପୋଲିସ ଏଇ ଯୋଉ ଫଟୋଗ୍ରାଫ ରୁ ମୁଁ ଯାଇକି ତାପରେ ପ୍ରୋଟେଷ୍ଟ ପିଟିସନ ଯେତେବେଳେ ନାଁ ପାଇଲି ମୁଁ ଦେଖିଲି ଆଜ୍ଞା କନେଷ୍ଟବଳ ପ୍ରେଦିନ୍ତି ନାଇଡୁ ଥିଲେ ସେଠି ପବିତ୍ର ସର୍ଦ୍ଦାର ଥିଲେ କନେଷ୍ଟବଳ 2 ଜଣ ଆଜ୍ଞା ମୁଁ ପେଜ 20 ରେ ପ୍ରୋଟେଷ୍ଟ ପିଟିସନ ତାଙ୍କ ନାଁ ନେଇଛି ପ୍ଲସ୍ ଆଜ୍ଞା ମୁଁ ତ ସବୁ ପୋଲିସ କୁ ଲେଡିଜ ଟା ଚିହ୍ନି ନାହିଁ ଆଜ୍ଞା ପେଜ 11 ରେ ମୋ ଫଟୋଟା ଆଜ୍ଞା ଦେଖନ୍ତୁ 2 ଜଣ ଯୋଉ ପୋଲିସ
Then why have you in the protest petition? Why have you implicated superintendent of police? And
ଆମେ ଦୌଡ଼ିଲୁ ଗଲୁ କିଛି କଲେ ଆମେ ମୋର ତାଙ୍କ ଏଗେନଷ୍ଟ ନାହିଁ ମୋର 2 ଜଣ
simply tell me whether it was a protest petition or a writ petition.
ନା protest petition.
Now it looks like a writ petition.
ଆଜିକାଲି protest.
That's the problem. You made it a writ petition thereafter.
No, protest.
That's the whole problem.
No, Lordship, what my Lord is saying, my Lord's experience, Lordship. I am not equally situated with my Lord in knowledge, Lordship.
But
thing is, it appears that I have taken the name. It is not what my Lord and friend is saying in law that I must know the name of the police. How could I know? A ladies will know the name.
Let us see 202 statement. Uniform and 2 police officers. Police officer wearing uniform.
Lordship.
And there was a white collar.
Man, the JCB driver. White collar man is the JCB driver. Say police 2 ଜଣଙ୍କ ଇଏ ଫଟୋରୁ ମୁଁ ଉଠେଇଲା ପରେ ଯାଇକି ଥାନାରୁ ବୁଝିଲା ପରେ ପ୍ରୋଟେଷ୍ଟ ବିଷୟରେ ନା ଆଣିବି ଆଉ ମୁଁ ନହେଲେ କୋଉଠୁ ଆଜ୍ଞା ଆଣିବି ଲେଡିଜ ଟା ଇଏ କହୁଛି ସବୁ ନା ରାଷ୍ଟ୍ରପତି ନା ଜାଣିବା କଷ୍ଟ ହଉଛି notice ଟା ଖାଲି ଯାଇଥାଉ ତାପରେ ମୁଁ ଫାଇନାଲି କନଭିନ୍ସ କରିଦେବି my lord.
Maintainability ଉପରେ ଆଗେ lordship act for maintainability.
I am partly convinced. See, I'll tell you one thing. What was the job of the police officer?
My lord, it was
The allegation that he has committed a mistake by the way he has drafted all these things. Very horrible. But what was the role of was there any court order or anything?
That he has not submitted.
You tell me after investigation you have closed it. And what authority the police had gone with the JCB with the
yes, there must have been some order. My lord, can you see page 26? Before that, my lord, can the person who has not implicated any person in the affair, can he raise the voice that in the protest petition that
now I frame that that's a different story. He is it's not a protest petition. It's
not, but it is a
writ petition now.
In the name of
but now you tell me why these people, these 2 police persons have gone there.
My lord, page 26.
So what are they?
Page 26.
To me.
My lord.
26. Yes.
I'm reading, my lord, the relevant portion, my lord. The middle portion, that however, my lord.
26.
26.
Order sheet.
However, if the act alleged against a policeman is reasonably connected with the discharge of his official duty, it does not matter if the policeman has exceeded the scope of its power or acted beyond the 4 corners of law. According to the complainant and other witnesses examined under section 200 CRPC, the accused police officers were present at the occurrence spot when the boundary wall of the complainant was being demolished. In the opinion of
the material you have collected, he is presuming that they are doing official duty. That's what I'm asking. Whether they are doing official duty, whether they have gone pursuant to some court order or anything.
Yes, my lord.
Where is that?
My lord, that I will take instruction.
I will take instruction.
But he has not done it. Why unnecessary person with the police personality and police
yes, he has created a blunder by how High Court has presumed that they were doing official duty.
Yes, ma'am. Why the police personnel they were
what good reason they have gone?
Yes, sir. That instruction I will take because he has not annexed that.
No, that in the initial FIR when FIR was filed by him
alleging that time in investigation you should have got that. But the investigation that final report submitted was a mistake of fact. Then after he has submitted what the mistake of fact, why the police officer said one, minor was there, minor. That for what reason he has in that also file it was not revealed, file report. Otherwise, they have to pay. But that is the entire order for us, he has not filed a police officer case as well to demolish the house. That was having some order. That's what I imagine. If there is order, everything will collapse. Yes, sir. I will take instruction in that in both the cases. Let me check. If you get that instruction, if that is clear, everything is yes. Can you get that? You instruction this Monday.
I don't know if it's not really minus 21. Not really.
For passing. This is for passing. That come out the investigation on. Investigation that's submitted. But all of them were that's it submitted on like 21/5/2020. Then 2020. Then my lord, except the principal artists, the present petition of side of the principal. They are not free. So they were discharged. Who started file against you? Only charges submitted against Raghunath Ponda, who is the principal actor. You are not there. So discharge petition, they are all already discharged.
You want to be accused? Withdraw it. Unnecessary. You are not an accused. Why should you file the passing petition? Did you follow what I am trying to tell you? You filed for passing of the FIR.
Yes, sir.
Investigation has taken place. Charge sheet is not filed against you. Charge sheet is filed against someone else. So therefore, you have to withdraw it.
Case nahi to main seita पूछ.
Common case nahi.
Yeah.
Kahin file kar. Right of responsible for the petition seeks to withdraw this petition. As in the charge sheet, none of these petitions are raised. Dismissal.
85.
Take up it filing.
Your Lordship, the present petitioner was inside the custody since 31/10/2022 for offence committed, Your Honor, 21C and 29 of NDPS Act. Before my submission, Your Lordship, I am there are 6 accused in this case, Your Lordship.
This is for cancellation of bail.
Yes, no, madam. No, Your Lordship. Actually, what happened, the petitioner was previously enlarged on bail as because non-filing of the chemical examination report at the time of charge sheet, Your Lordship. Subsequently, with a precondition, the Honorable Sessions Court directed that when on subsequent filing of chemical examination report, if it will be brown sugar, then the bail will be rejected automatically, Your Lordship. Initially, he was granted bail because the agency didn't file chemical examination report within the time. Subsequently, on filing of chemical examination report, his bail has been cancelled, Your Lordship. My contention, Your Lordship.
That is what is the judgment of this court. What to do?
No, Your Lordship, that's judgment.
You have filed a 482 petition for grant of bail.
For grant of bail. This is a 482 petition.
This is a 482 petition. 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 4
So that order, I have came with the order of that additional session judge, your lordship, because.
Who has cancelled the bail?
Huh?
No, no, my lord, whether he surrender or not, that
There is a judgment of this court. You might not have came across the judgment.
Yes,
Judgment
lordship.
of, I should not take the name, but for your facilitation, I am telling you, judgment of Justice R.K. Patnaik, who has said that if the chemical analysis report is not filed along with the charge sheet and the petitioner is entitled for bail, but subsequently if the chemical analysis report is filed, it can be recalled also.
Your lordship, taking into the consideration of the fact and circumstances of the case, your lordship, because in SK Idmat for Ilyas Vidya versus that is the your lordship.
This is the order. Yes.
You have you gone through this judgment?
Yes. On the lower, your lordship may kind go through the lower portion of the order, your lordship.
Right.
Where?
Para 11 and 12, my lord, was clarified. Para 11 is not relevant, para 12 is.
On subsequent filing of chemical examination report, your lordship, the court can never mention that the bail will be rejected. In this case, your lordship, nothing has been nothing has been said from my position, lordship. There are 6 accused. Nothing has been said from my position. Secondly, your lordship, the chemical examination has been filed after 1.5 years, violating the mandatory guideline given by the Narcotic Bureau, your lordship.
Simply, your bail was granted, it was rejected after the chemical analysis report is filed and you are taken into custody. File a fresh bail application. Why are you creating a constitutional issue out of it? I don't know. Filing 482, this, that. Why are you doing all this adventurism? Why are you not filing bail application, argue on merit?
Previously, I have already filed. This was pending since last 5 months, your lordship.
Simple matter, you are making a constitutional issue. Your bail is rejected, you are in custody, file a bail application, you say that the judgment is not covered, I am not covered by the judgment, and you will get the bail. If you are not getting bail, approach this court under 439. Why you are entering into all these issues? Withdraw and file appropriate petition, and you will get the bail. Don't worry about it. Okay?
Yes, I oblige you, Lord.
I'll just give you that liberty.
Okay.
And you please withdraw it and file a better petition for grant of bail. Okay. Right on. Legal counsel for the petitioner seeks to withdraw the present petition to avail his remedy under section 439 CRPC with the liberty to approach the appropriate forum under section 439. The present petition is disposed of. Okay, you file 439. I thought something big has happened.
No. Yes, my lord, on interim bail, that interim bail condition was there. He has challenged.
And he'll get bail.
My lord. In the meantime, my lord, chemical examination report also available.
On that basis, what is the recovery, by the way?
My lord, that empty jury was seized. All were selling brown sugar. From 2 of his persons.
Quantity.
My lord, from
890 gram. Out
from
of
one person 400 gram, another person also 400.
No, another person, he is not. Personally, he is not. I am not. Yes, yes.
Okay, yes, next.
86. My lord, I am through VC. I need 1 week time to remove the defect, my lord. There is 2 defects, 6 and 8. I need 1 week time to defect.
What are these defects? Whether
I don't know, my lord. See, as for 6 is a copy not served. I will serve that copy. But as for 8.
1 minute. If these defects are ignorable or these defects are ignorable, ma'am, forget it. Argue if you have a case on merits.
Well, next week I will argue. This is the matter.
Meanwhile, do it. I am not saying anything. I am simply urging
yes,
you.
Next
Cure the defect.
Next week I will.
But these are ignorable.
Oh.
Ignorable.
And kindly direct to serve a copy that he has not served.
Yes. By tomorrow I will serve. By tomorrow I will serve.
Okay, next week.
Next.
Yes.
7.
Yeah. Non-AVA.
Requesting to be adjourned, my lord. Mr. Srimanta Das will be appearing in this matter. He's not
Srimanta.
present. 1 week after.
Mr. Simanda. Yes.
His name may kindly be reflected in the cause list. Remember.
88.
Yeah, please. Well, the appellant is expired.
Expired.
The appellant is already expired, so I filed the certificate petition and the delay of annulation.
Where is the application? The sole appellant.
Sole appellant.
The sole appellant has expired. The LRs of the sole appellant have filed this present application under section 394 CRPC for continuing for permission to continue the appeal. When has he died?
22/5/21.
22/5/21. Allowed. Amended to be more parties to file within a week. Confirmation of delay application for the reasons stated in the application, the delay is conducted. Yes. Formal objection. Mr. Rijvi, yes.
89.
89 is a trap case, my lord. Why it is listed? Is a trap case. So let it be listed for hearing in the week list.
Why it has come to supplementary? Is this supplementary weekly? Specific name, no. Specific then. These are 5 weeks. No, but none appears for the petitioner. List in the weekly. Okay.
So instead of S Das, my name may kindly be reflected. SK Das.
Yes.
Item 90.
Item 90 was adjourned perhaps on the first hour. Mr. Marana and Mr. Amit Nath were there. I was told by Mr. Marana that it has been adjourned.
So Marana was asking to 91.
91 one passover man.
Passover.
91, he has been dismissed from service. He has filed the documents.
These are criminal appeals, whether he
Appeal.
dismissed or not, how does it?
Yes, appeal. He filed certain documents along with this application. So I got the instruction that he was on leave, unauthorized leave. He was not getting any salary.
What is the relevancy of those things in this appeal? Nothing.
So he was subsequently dismissed. In 21, he was on leave, unauthorized. So he filed for stay of conviction.
Stay of conviction is not to be allowed. You talk about the merits. If you want to argue on merits,
You want passover man.
adjourn. Weekly done. Weekly. Yes.
92.
It will be listed in the weekly hearing list.
My last occasion also directed to file objection minor.
92.
Not required, no stay of vacation. His lordship is
Okay.
not in plan.
Okay.
He has been dismissed in the meantime.
Okay.
It will be listed. Then come back with the document. With the position person.
Previously.
No, already I have passed the 92. Why? 92? There is no. Since this matter is not assigned to me, let it be placed before the Chief Justice for assignment. Pramod Kumar Vishal.
If your lordship pardons that matter.
Which one?
91 man.
91.
I just crossing in through staircase.
I am putting it in the weekly list to be heard.
Your lordship granted him time to file objection. He has not yet filed objection.
He has come with your
Just try
dismissal
my
order.
luck.
He has come with the dismissal order.
No, his dismissal order is in respect of one employee, not both, I think. Let him give a copy to me. My
Give
instruction
a
is
copy,
please
let it be there 1 week for the.
That is one point.
Yes, yes.
And he is not
Blame,
filing a
blame.
reply to this, but he is interested that he should be dismissed from service.
Yeah, already received.
Your lordship has been pleased to grant him more than 1 more time, if I am correct.
Now he got it, just see what can be
Got
done.
the instruction of dismissal.
No, but
Get
that is-
ready, don't waste time, get ready. If you are there, sometime we will hear it and finish. If you have good case on merits.
This part also I.
Whether he
try
dismissed
my
or he
luck.
not dismissed.
No, that is one part
Neither
of
here
it, but
nor
to the stay application, your lordship was pleased to grant him time. I think he has not filed a reply. If he wants to assist your lordship without a reply, I'll assist also. On the next date, your lordship fixes.
2 weeks for yes. Yes, what happened 92? Not assigned to this bench or something you say. Huh? No, this is it went to Justice S.K. Panig, right?
Yes, sir.
And then he passed the order that it should be listed before assigned bench. Now it is not assigned to me. Verify and tell me. Verify and tell me. Okay. 93.
93. May I please, Your Lordship? Challenging the order of taking cognizance dated 29/4/22 Millet passed by the learned SDJ Baleshwar in a complaint case under section 138 of NI Act, annexed to page 14 Millet. He is a complainant, he is a businessman, and the petitioner is also a businessman, namely Gitanjali Motors. And they allege that the petitioner took rupees 23,50,000 from running of a business of a new tractor company. Check
What
was
are the
issued-
grounds for quashing?
My lord, quashing grounds, my lord. One was,
You have issued the check or not?
my lord, check was issued in the name of the company, my lord. But complaint petitioner filed in the name of the petitioner, my lord. Money was transferred from Mahapatra Aqua Farm to Gitanjali Motors, my lord. And also check was issued by Gitanjali Motors to Mahapatra Aqua Farm.
These are the.
And law is well
companies.
settled in a case
That's
of
the proprietorship.
Proprietorship.
Your lordship, that for that purpose, a judgment is there of Honorable High Court.
on the case, my lord.
Very simple.
Honorable-
Proprietorship.
Proprietors.
Then you have issued check, then
Lordship,
don't bring those company not implicated and all these things will not help you. It is a proprietorship. Show me the complaint. Show me the complaint.
Your lordship, the check and
Show me the complaint. Copy of the complaint.
Yes, ma'am.
My lord, the second money was issued from HDFC Bank, my lord, but in cognizance order it has been mentioned Punjab National Bank. Let me kind glance. Look up.
Merely there is a typo doesn't mean that everything is washed away. It is a 138 case summary proceeding. You have issued a check, it got dishonored. And you have to, if you wrongly prosecuted, statutory requirement not followed, these are the grounds. What ground you have? Absolutely, there is no
in the
ground.
case of Anita Adi case and also Anil Gupta case, my lord. Prosecution under section 141 of NI Act cannot be maintained without alleging the company as an accused.
Where is the company?
I don't dispute that. Yes, 140, it is not a company.
That's the law, everybody knows it. Where is the company?
Gitanjali Motors.
Gitanjali Motors Private Limited?
Yes, sir.
Gitanjali Motors Limited. What is that? See your company. See your complaint. What have you written?
Lordship, I will check. Copy of the check, my lord.
I complaint, I have to read the complaint. Complaint, what have you written? See.
The complaint, my lord.
23,50,000.
Yes, ma'am.
What is this says now?
Already we have adduced evidence. They are supposed to cross-examine us. They are taking time by this order, since interim order is passed. Therefore, the case is not proceeding, ma'am.
Nothing. Petitioner has filed the present petition detailing the order dated 29/4/2022 passed by the learned SDJ Baleshwar in one CC case number 222 of 2022, whereby cognizance of offence under section 138 NI Act has been taken. The sole ground of challenge to the cognizance order is that the petitioner, the complainant, the petitioner had issued check to the complainant in the while in a business transaction. The petitioner is running a business in the name of what motors?
Gitanjali
Motors, which admittedly the proprietary.
And also that
proprietary
farm is
section.
also motors,
So
means
since the-
Mahapatra Aqua Farm.
And the complainant is running a business in the name and style of Aqua.
Mahapatra Aqua Farm.
Aqua Finance. which is
Aqua
also-
Farm. Mahapatra Aqua Farm.
Aqua Farm, which is also a proprietary firm. Since the ground that without impleading the Gitanjali Motors, which cannot be prosecuted, is not well founded under law, as it is a proprietary concern. Therefore, the trial court has rightly taken cognizance of the offence. Cognizance of the offence under section 138. The trial of the complaint case is at an advanced stage. I am not inclined to entertain this petition. Accordingly, this is dismissed. And all the contentions are left open to be addressed by the parties before the trial. Yes.
94.
94 same, my lord.
Yes, same, my lord,
94
but
also same.
the another lords may kindly glance and the agreement between the Gitanjali and Sagatika, my lords may kindly glance. The petitioner and the opposite party on 16/1 to 13 to sell a land, my lord. Advance of rupees 1,20,000 was given by the opposite party, my lords. Sagatika denied to purchase the land and demanded to return the advance money, my lord. And check was given by Gitanjali on 2014, my lord. Subsequently, cash was given to the opposite party, my lord. The opposite party did not return the check. I have issued the check in the year 2014, my lord.
All these things are your
Thereafter,
so unnecessary.
Thereafter, my lord.
I'll keep all the contention open to be addressed before the trial.
1,20,000 সেটা enhance করি সে 9,30,000 সেটা করছেন। That is the lordship may kindly glance the signature. Check has not been.
See, the fact remains you have issued checks and which are dishonored. Today, this ground, that ground, you are taking interim order and not paying the money.
No interim order is that, my lord. Blank check was issued in the year 2014, my lord. Subsequently, it has been manipulated.
Why have you issued blank check?
Yes, taken for
Those things have to be gone into trial. Can it be decided? Well,
Whose handwriting is there? Who has filled it up?
No, written date was not written, my lord. Date and
gone into by the trial court, not in the cognizance stage. That counsel for the petitioner seeks to withdraw present petition to raise all the issues, all the points he is raised in this petition at the appropriate stage of the trial, with the liberty to raise all the points before the court below at appropriate stage. The petition is disposed of.
Both the cases, I'll raise all the points at the time of trial, man.
I have that I kept it. Yes.
95.
That's 95 on behalf of Ms. Chandana Mishra. I pay for 1 week afterwards.
1 week.
1 week afterwards.
What is this matter?
The opioid matter, my lord. Here challenge the discharge petition has been rejected. The discharge petition has been rejected, my lord. Against that, he has filed it.
Any interim order?
No, my lords.
Discharge application rejected in 2022.
2020, yes.
What happened now?
My lords,
Discharge application rejected in 2022.
Present status.
also I will obtain that instruction. I will inform.
Why should you keep it pending? By now, charge might have been framed and evidence must be going on.
No stay is there, yes.
My lords,
There is no stay.
my lords, I will inform the conducting counsel
Tomorrow.
My lord.
Tomorrow. Get the instruction tomorrow. I'll dispose it.
My lord.
Nothing to do.
My lord.
Tomorrow, day after tomorrow. Come. You see
Yes.
instruction. Nothing survives in these petitions.
My lord, sir.
Unnecessary, yes.
96.
May I please, Your Lordship? All the three petitions are there before Lordship. I pray Your Lordship to take up the second matter. Second matter, 3881. Because the first matter,
Yes. What are you challenging?
I'm challenging the proceeding because this is a case relating to 138 NI Act, and the case is now proceeding without there being any order of cognizance. That was the last occasion Your Lordship put that question to my learned friend to obtain a instruction as to under what circumstance, without there being any order of formal order of cognizance, the proceeding can further proceed. Your Lordship, for that purpose, I draw Your Lordship's kind attention.
In all the three matters are like that.
No. Three matters. First item 3073 and this present 3881 relating to 1CC 2808 of 2021.
Same accused.
Same accused, same complainant.
Same check.
Same check. Another check is that item number sub item 4182.
How many checks are involved?
Total 2 checks are involved.
Amounting to?
Amounting to 25 lakhs. No, sorry, in 17 lakhs. 17 lakhs. I'm sorry. 17 lakhs.
Why have you issued all the checks to these people?
My lord, here this is a case, my lord, as per the complainant, that the complainant has paid certain amount of 25 lakhs to the son of the present petitioner for the purpose of getting a seat in the medical college, government medical college. And when he could not able to provide that seat, and that he was a part of that, he and his son is also, her son is also there inside custody.
Check to save your son.
Yes, that circumstance was done. These present complainants are the police personnel. So by that influence, she was under compulsion to issue checks to save the son. Thereafter, the check got bounced, and this case has been filed. My challenge is twofold. First thing, that in this 2081CC, first thing is that there was no order of cognizance. Before condoning the delay, there was no notice issued to the accused, and without taking cognizance, without affording opportunity for before condoning the delay, the case is proceeding. Another point is that whether the check can be, the prosecution can be maintainable under NI Act for the in discharge of any debt which is not legal.
Legally recoverable debts.
Exactly, Your Lordship. That is my main point. For that purpose, I will have to take Your Lordship to Contract Act. This is not a valid contract.
Don't take me to Contract Act. What happened? Is there any criminal case against your son?
Yes, Your Lordship.
You're facing?
Yes.
That is the liability. You have taken money to arrange a medical seat, your son.
Yes.
Your son could not do it.
Yes.
Thereafter, the people, those who have paid money after your son.
Yes.
To save him, you issue a check of 70 lakhs.
Yes.
It got dishonor. Obviously, your intention is only to avoid that your son should not be in trouble. You have not only 138, you have done other crimes also.
No, my lord, my point is,
you are a party to, you are one of the conspirator with your son.
no, my point is the purpose for which he had
bringing all kind of technical issues, this happened, that happened.
No, my lord, my sole point before Your Lordship is, in the event, let us assume that
you pay back the money and filing quashing, and your son will also be get out of this problem. You will also get out of it.
No, my lord, my son is inside custody.
Inside the custody.
He is inside custody because of in another case. Here in the criminal case also, I am also implicated, one of the accused, and my another son was implicated and accused. I was arrested,
And while before producing in before the magistrate, I was also subjected to harassment for which I lodged the complaint before the Human Rights Protection Cell. I will not that say that in this case because that has no relevancy with this present case. My sole point is that whether the amount which he can maintain any case for the amount for the purpose whether there is kind of the government that some in order to get a seat in the medical college someone is required to pay money. If at all to my son, not to me, why he paid? He's a government servant. He's a responsible government servant. He's paying money to the.
What is happening in that NEET examination and all, you know that.
20 cases pending against the son of the petitioner.
You allure people that I'll arrange a seat for you, and every parents are crazy to get their children admitted to good colleges. They come under your influence, they pay. Thereafter, you bring all kind of technicalities that I have not.
I'm not the person who has taken the money.
Your son has not given it. To save him, you have given a check.
He's in custody. He's in custody. He's not saved. He's in custody. But my 2 points here, whether that debt is legally enforceable debt or not, that lordship will have to take a decision. I have got also some decisions on that point. Another aspect is that whether the court case can continue without any order of cognizance. There is no order of cognizance.
There is no order of cognizance?
No.
Well, as per the decision, Kishore Polley and versus Arun Kumar Panda, my lord, it is the status of summary procedure.
In fact, these are summary proceedings.
Yes.
They are summary proceedings.
In the petitioner.
And unless there is completely illegality is happening.
Section 142 is very much clear. 139.
What judgment you are saying? Will you pay in installment?
My lord?
Will you pay?
No, I have not taken the person who has taken. He is inside custody. He is inside custody.
Have you dishonored your son? You must disown your son.
20 cases against the petitioner's son, my lord.
Against my son, 20 cases, 200 cases, it has no relevancy with the present case.
Which paragraph you are showing?
My lord, paragraph 14, my lord. 14.
Paragraph?
14.
Page?
Page 8.
8. Okay. Read it.
It is brought to the notice of this court that the judicial magistrate in the state of an order of the summons procedure for trial of complainant under section 138 of the NI Act without passing an order in accordance with the second provision of section 143(1). This court therefore directs that a copy of this order be forwarded to all the session judge, chief judicial magistrate, and judicial magistrate first class for future guidance. The judicial magistrate first class shall enforce henceforth conduct trial of complainant under section 138 of the NI Act, keeping in view of the observation made herein above in all cases in which evidence from both sides has not been closed. Whenever evidence from both sides has already been closed or complaint already been disposed of, the matter shall be reopened for fresh trial by magistrate, or as the case may be, by the appellant or revisional court. Next para, my lord.
What do you want to show me?
My lord, page 5, para 3. Tell me.
You tell me what you want to show me.
My lord, for the it is starting from summary procedure. As per the judgment, and this judgment is quoted in this order. Also, is
have you followed what legal issue he is raising? Have you followed? Summary procedure, everybody knows. He says that even if in a summary proceeding, without taking cognizance of an offense, the summary proceeding can't start. That's what he said in a criminal prosecution. Have you followed the legal issues he is raising? This is one. Second is, even if he has paid the check to you in lieu of for the illegal money which his son has got it, since it is not legally recoverable, so 138 is not. That is what his two issues.
Check has been issued, my lord.
check might have been issued, but it is as against legally recoverable debt. That's the expression he used in 138. He says that it is not legally recoverable. It may be recoverable, but it is not legally recoverable. That's the thin distinction he is making now. It is recoverable, obviously, because he has you have paid to his son, in lieu of which he has paid to you the check. It may be recoverable, but it is not legally recoverable. That's the distinction he is making. Will you prepare it in these 2 points?
Next,
You prepare it. He technically he has a very strong case, I tell you.
well,
Technically he has a point, therefore he is standing rock hard here. Otherwise he is in deep in trouble.
20 cases have been pending. I am annexed the FIR
You
document.
answer, this is a very technical issue. You please answer 2 questions, whether without cognizance, whether a summary proceeding in 138 case can be proceeded. And second is whether even if it is recoverable, if it is not legally recoverable, whether 138 maintainable. These are the 2 issues he is raising. Please address it. Otherwise, you will be in trouble. Technically, you will be in trouble. Okay. 1 week. Note down what these legal issues which I have formulated for you and just see any judgment, anything. Yes.
Interim order is there.
Well, continue. I'm not
But-
saying it. Yes. Continue.
The second case with
Simply adjourn. Simply adjourn. Yes.
97.
So far as my appearance before Lordship, whenever I appear before Lordship, I am very much comfortable because I know that whenever that I need some sort of advice or instruction that I can get from this bench.
No, these are legal
We are-
issues has to be addressed.
Yes, Your
That's
Lordship,
the
yes.
problem. And he is apparently not prepared on that.
97.
Item 97, where the in action of the landlord JFC Kantawanji,
I filed,
not
my
taking
lord,
step for display of
another
the one
case.
CC case arising out of 130 10 Act as well as I. And Lordship was pleased to issue notice and pursuant to notice and has appeared.
Yes, I have, my lord, I filed another
Complaint has appeared
CRLMC,
2022, my lord.
1846,
Almost 2 years have
my lord.
lapsed. Lord, trial court is
1846. Check amount?
5 lakhs. my lord. Lord, trial court is sitting.
My
silent over the
client
matter.
has paid, my
The
lord.
statute says that 6 months. At
Yes,
least.
my lord, that's correct. My lord, I filed another case, CRLMC number 1846 of 24. That was before my Justice A.K. Mahapatra. And there is an order, matter will be taken up on 7th along with this matter. And I have also another, I have filed one,
What is that matter?
that, my lord,
Arising out of the same.
yes, same, my lord. And I have also filed another, my lord, passing of cognizance and initiation of proceeding because suppression of fact and there is one FIR has been filed on the self-same and that's also no clue, that's false and that has been dropped. And that has been suppressing all the facts that another story has been created in this case.
No, I
And
have a clear-
my instruction, Lord, the petitioner has already paid, Lord, 10 lakhs 55,000.
Check amount 5 lakhs. How can my
And
client
yes,
pay
yes,
10 lakhs?
but because what happened,
Here my- I got
his is
No, his grievance is only simple.
yeah, for disposal,
He said
direction
that,
for disposal.
yes,
of the-
since
you
I,
filed a case,
yes,
it's
yes,
not
yes,
getting
yes, my lord.
disposed.
But since
And you
I,
simply
since
observe it and.
yes, my lord, since the
Can
IA
we
has been
dispose of
filed
that?
for a stay of further proceeding, this will
You have
be-
filed it.
I have filed, my lord. And that's why if this order will go there and my matter will be infructuous.
His property is
And
challenged.
yes, my lord.
And he is asking stay of the proceeding. If
Yes,
I
Lord.
target it or something, then that.
Let it come along with that matter. then.
Yes,
And
yes.
that court says that both the matters to be heard together.
Yes, my lord.
Let it go.
Yes,
That court.
yes.
That would be the ideal thing.
Yes, yes.
I should not pass any order which will
Yes,
threaten
ma'am.
that proceeding.
Yes.
Okay, lease the matter along with
Yes, my lord.
so and so. Huh?
Yes. There is a order for, in that proceeding, order has been passed to.
I will simply say that lease this petition along with that.
Yes, ma'am.
Let it go anywhere.
Yes,
It may come to
CRL
me or it goes
yes.
somewhere else. Wherever it goes,
Yes,
we'll
ma'am.
hear it.
CRLMC 1846 of 2024.
Yes.
Yes.
Counsel for the opposite party, number 2, So say that the connected matter being so
Yes,
so
yes.
so and so.
Serial
is
MC
listed on
1846.
Listed on 7th.
Yes,
Please,
ma'am.
please this matter along with the same.
Yes, ma'am.
Yes.
98.
My lord. The petitioner challenging the order dated 26/9/2014 passed by the Lord and District and Session Judge Bhadrak.
2014.
My lord. 14 and incident is more than 2.5 decades. Already 2 persons already been accused, passed away.
Okay, okay. I thought it's some
And conviction
conviction.
under 326 and 149
Yes.
IPC on 48.
In the appeal, it is confirmed.
Appeal is confirmed.
Yes.
And there was a case and a counter case. The genesis of the case,
Yes.
admittedly, there was civil dispute. And arising out of a civil suit and ex parte order, possession was given.
First of all, you tell me, are you sure that all the petitioners are still surviving?
No, not during a trial and all persons surviving 10%.
No, today. Because in
Today,
2014, you filed this revision.
No.
That time, one of the petitioners was 75.
4 is 85.
My lord.
4 is 85. 85 and now 10 years, 95. Are they surviving?
Only 1865.
No. Instruction that
You have to
all
take
are
instruction
surviving.
because-
Surviving.
Only 2% has been died.
Who?
As stated in
2%
the
trial man.
trial, during trial, my
No,
lord.
I'm not talking about trial. I'm talking about during pendency of this petition, whether number 2 and number 4, those were 75 and 85 years old in the year 2014, still they survive or expired?
Another one is 8. It's number 8, madam, who was at that time 65. It's number 8.
Take instruction tomorrow or day after.
You have to seek instruction. Because if they have died, we can't pass any ordering there. Yes. Then counsel for the petitioner seeks 1 week time to ascertain the well-being and whereabout of the petitioners. Those who have crossed petitioners. Please the matter.
Yes. 99.
My lord, this case may be taken 2 weeks, sir. My lord, I have given a pen drive filing.
You can take it. Next, so
And 100.
I'll take it.
stop it here. Okay. 100.
May please, your lordship. Lordship, just to refresh your memory, that my lord, I am submitting that the husband of the petitioner has been implicated in a vigilance case under section, my lord, 13 to the 13(1) and 7 of the PC Act, my lord.
Who you appearing? 100. What is this?
This is an application by which the family is involved in rejecting a post release an application for any of bank. There is no beyond that. Rather, it's a I appreciate this one. Doctor can take a prayer at page 14.
Only fixed deposit.
Page 14 words contains only the fixed deposit is up to be basic release of that one.
TDR deposits.
Yes. These are all contains the page 20 contains the regions. And in fact, the operating portion order strategies are around 8 marks. That is a very reason orders not in fact the London High Court has allowed the The accused wants to operate all these numbers, keeping all those money on the date of.
Sorry, Lord. I'm sorry, Lords.
Mhm.
Page 80, page 20 of Lordship brief, Lords, contain the paragraph 8, Lords. The learning trial courts, Lord, allowed the accused prayer to operate all these seized accounts, Lords. Keeping that money to be kept intact, Lords, on the date of the house search. That is on 12.
12.
How it is unreasonable? How can be faulted with, Lords? And with regard to the prayer press prayed for the Lords, and you know, that is
Involved in all these accounts?
in all these accounts, Lords, in FDs, Lords. A number of FDs, Lords, he is seeking for a discharge,
What
Lords.
is the total amount?
Total
Do you have
amount.
any idea what is the total amount? Yes, Mr. Mahapatra.
My lord,
Lords,
that
page
vigilance
23,
policy,
Lords.
my lord, that vigilance policy that says that all those the FD accounts, that was the maturity value, my lord. That was not the, it is TDR, matlab term
I'm
deposit.
asking something, you are answering something. What I'm saying is, the FDR, what is the total amount in the FDR you have?
Total amount, that is the maturity amount, which is 37,86,479. And my lord, I have submitted the my lord,
Are you,
your
are
lordship
you,
has
can you give me bank guarantee to that extent?
Yes.
bank guarantee.
Seek instruction, tell me.
Take instruction that will take up so tomorrow.
I'll release everything. You furnish bank guarantee.
Bank guarantee, how many?
Or property security to that.
No. I don't stand because again that will drag some
Bank guarantee only.
bank guarantees, my lords. I
Think
agree.
over.
Let him take instruction. Let it come tomorrow, my
Day
lords.
after, day after, day after. Yes.
No, tomorrow, no, lordship, no, through 3 days after.
Next week.
No, next week. Yes.
101. Yes, sir.
101 before my lord senior submits, my lord. This is one case, my lords, where this on court was pleased to stay the vigilance proceeding in a DA case. It will take some time.
Where is that order?
Lords, you can turn to page 64, lords.
Is it your case or my case?
5 weeks stay.
Page 64 is the orders. And that one, because we both are crossing shoulder with each other on that particular bench, we sat, yes. That particular bench sat for 1 week. And my lord, for this one line observation at page 64, the accused may have a good case to ascertain, but this is not a stage where the same should be analyzed. This is a good case. But only for that one line, my lords, the entire vigilance proceeding can be stalled, my lord. That's why, my lord,
that is not the case.
let my lord senior argues for
No.
any time he wants, my lord. But little bit is
Please
for
sit down.
lords.
Please sit down.
No, I can't. I can't. This kind of order is
Yes.
rare.
This order 23/2/2024 order, last line is stay. Huh?
The 64,
right?
page
It
64.
remains state in the next date.
That's why, my lord, I'm anxiety. Let my lord senior argues. Let him argues what a DA case, my lords. Husband, wife, lordship, my lords. And my lord, they have challenged and orders, my lords, rejecting the dissent application. And this is application rejection was stayed by this on court because the one line observation and trial court which was read, which was placed in a distorted way, saying that the accused may have a good case to ascertain, but this is not a statutory. It's a good case. But it raised it in the trial, before the trial court. For that kind of perception, my lords, of this on court will get respect, my lord. Entire vigilance proceeding is stalled. This is one of the very few cases, my lord. I boldly stand for what I stand for.
Are you complaining against the interim order passed by the court?
No. The thing was placed in a distorted way.
You should have challenged that order.
In fact, I'm here, my lords, to challenge that order.
Anyway, we will hear it and finish it up. Why
Yes,
not?
ma. That's what my entire anxiety, my lords. Let him argue any matters. Lords, dispose him.
He has been waiting. Let us see what.
No, I'm also, only for this one case, lords, upon 10:30. I'm also here.
Yes. I'll see. But what is the case?
Yes, I'll come to it, my lords.
I'll only for 5 minutes. Let us
Yes,
understand.
I will only address my lordship for 5 minutes. My learned friend should learn by now that he should stop talking and allow the counsel who filed the petition to argue this.
No, I have taken the permission of this court and appraised this on court. What is the urgency in this case? Why I'm so strong?
My lordship would learn.
You are hurt by the stay order, obviously. Because,
My lordship, I have submitted a written
Just
note.
give me overall
Yeah,
idea.
very, I will only bring it into I will only show 2 pages. My lordship sees them from the brief, page 20.
The very interesting thing is your revision petition is 13 pages. Your written statement is crossing 20 pages.
No. Those are the annexures of the judgment. Only 6 pages, 4 pages.
I prefer to see your revision petition instead of
My
seeing
lord,
this.
my lords, only 6 pages is what I have written. My written note.
Tell me what is it, please.
My lordship, turn to page 20 of my brief.
20. You have given now.
Yes, my lord.
Yes.
No. The brief, the revision.
Revision. Yes, sir.
My lordship sees investigation was conducted and ultimately they came to the conclusion and the FIR was filed where they said the disproportionate asset is to the tune of 138.
139. Yes.
139%.
You are working as what?
Engineer.
Assistant engineer. Then my lordship would turn to page 49.
20, 40?
49.
Yes.
From 139%, my lordship sees they have come down to final charge sheet 38. Has my lordship got it at the bottom?
I got it.
The crux of the matter,
You should be happy.
if it's 10% and less, no case.
38%.
10% and less. Disproportionate asset, no case, no cognizance can be taken as stated by the Supreme Court.
Yes.
My lordship sees this is the final charge sheet. Then my lordship would turn to the next page.
Yes. 50.
50.
Yes.
He submits the charge sheet on 13/10/22. My lordship sees the order of the Honorable High Court that the order should be passed by, investigation should be completed by, with great respect, by 10/2021. That is at, before my lordship sees 54.
Yes.
54.
Yes.
54, the percentage of the disproportionate asset is 139 at the middle portion. That was the FIR. From 139, they straight away come down to 38 at the final submission of final charge sheet. Please, would you stop it?
Yes.
My humble submission, in Bhajanlal's case, it categorically stated, which I have quoted it and stated there, that if it is 10% and below, in B.C. Chaturvedi's case and also in other case which I have just referred, they said no cognizance can be taken. That is my first leg of my argument. The second argument which I have contended, once the High Court passes an order that under no circumstances you are granted 2 months' time and nothing more to file the charge sheet, they file the charge sheet after 11 months. Under the pure theory of law, this is very interesting, which my lordship will propound, I am stating this, under the pure theory of law and under the powers under 482 by Kelson, it categorically states that once an order is passed by the Majesty, the court, in certain eventuality, that is the period of limitation should be taken into account. And because the Constitution of India is the higher law and the statutory laws which you try to follow, the Prevention of Corruption Act and other acts, are lower laws.
Are you proposing that since the High Court has said that you file the charge sheet within this time?
Yes.
The charge sheet is filed subsequently.
After 11 months.
11 months. So therefore,
it should be totally ignored.
High Court has fixed a limitation.
Yes.
And limitation is crossed, so the entire charge sheet should go.
Yes, that is my second leg of my argument. Why? Which if to state that, my lordship would turn down to the notes. It's only one
At
paragraph.
the same time, the court should not interfere in the investigation process.
Court should not
See-
interfere.
See, these are the.
No,
if
this
they
is why I'm.
violated the order of the High Court.
Ah.
Remedy is somewhere else, but you can't say that the entire charge sheet should
Yes,
be thrown.
for that, I have only stated something which my lordship would see. I would only read that portion. This is only the second leg of my argument. These are the twofold arguments.
Second, you don't labor on the second one. I am not agreeing with you.
No, but
Try to impress me on merits if you have a case.
yes. So what I suggest, my lordship, on merits and 45 judgments of the Supreme Court, this is another point which I have raised. Why before my lordship?
Right.
Why law can be expanded. I thought this is the right place where the law can be expanded. My lord, we are always on the trodden lines. What I'm trying to contend, under the pure theory of law by Kelvin, Kelvin has stated this on the pure theory of law, which I learned it recently, that there is a higher law and a lower law. Higher law is the constitution.
Evolution of law is one thing, adventurism is another.
No, but my lords, what they have stated, the higher law is the constitutional law came along with the independence. Lower law, which is assembly and the parliament, the lower laws came into existence. And under the criminal procedure code also, there is a limitation provided. It can be extended, it can be curtailed. I've quoted that. That is the second leg, which I'm not.
468, that provision is there. In
Yeah,
the
it's
CRPC,
there.
there is provision.
There. But that is relating
Limitation is
to
prescribed in
relating to
468.
summons case. But in another provision says it can further bring in, enhance or delimit the limitation. I've quoted all that. That is not my crux of the matter. My crux of the matter is from 138, when it comes to 38%, when calculated, it comes to -6. I have no case.
You emphasize on that. If it comes below 10%,
Yes.
then you are out. You emphasize on that.
My lordship turns to page 3.
Page 3.
Written note of argument.
Just emphasize on that. And
Only page 3. I've given.
yeah. -6.77.
Yes, that is what I have contended.
If you-
And my lords,
if your figures are to be believed.
they are the figures of prosecution. Wait, please.
One minute.
My lord, let him.
1 minute, but I am not finally, Mr. Das.
We are
I'm
not finally hearing it.
Before placing any particular note or submission, does not disobey and copy.
No,
That's what kind of
this is
calculation
not
it
an
is?
argument. I am just trying to understand what is the case.
Yes, what is the
Because he has
case?
been
We are
waiting-
not arguing today on merits. Here, my lords, the Supreme Court stated, without controverting the figures and the facts as it stands in the investigation, which is what I've given, it comes to -6. This is the whole case.
I understand.
So therefore, my lordship would
Then
fix it.
you have to only satisfy me
Yes.
from the charge sheet.
Yes,
their
only
own
from the
figures-
charge sheet.
From their own figures.
Yes.
If
For example,
the calculations are done.
yes. For example,
Comes to less than 10%.
my lords,
Then you are out.
yes, my lordship.
From their calculation.
Yes,
Don't
yes.
bring your figures again.
My lordship would turn to the brief. For one minute, I'll take.
And I understood the whole gamut of.
No, I'll take 1 minute.
Yeah.
My lord,
Which
1
page?
minute I'll take.
Which
No,
page?
no, no. My brief.
Yes.
That is page 17. That's it.
17
FIR. Their FIR.
petition you are.
Huh.
Yes.
Upon turn to page 18, my lords. Turn to page 18. Running page 18.
Yeah.
Serial number 27.
Yeah.
And serial number 28.
Okay.
Does my lordship find any difference in the amount of 1 lakh, 1 lakh?
That is the reason it from 138 to it came to 38.
No. Much more. I will show it to my lordship. No, I'll show it to my lordship.
38% is all right. But how from 38 to you are bringing to -6?
Yes, that is what I'll show.
38, no problem.
No, then my lordship would turn to page 8. Page 8. 7 and 8.
That's the reason, overlapping.
7 and 8. My lordship sees page 7, last bottom. Page 8, my lordship sees. What is the calculation percentage? Asset
plus expenditure minus income divided by income. That is the calculation. Expenditure, then assets, that becomes minus income divided by income. Whatever would be the amount, that is the disproportionate assets. Whatever I have quoted here, then my lordship sees below.
Yes.
Just at page 8. I've given the same what they have given. That is 38 I've shown. Has my lordship got me?
Yes, yes.
Second line.
Yes.
Then my lordship would come down to the bottom.
Yes.
To the bottom. Excess cost shown in expenditure. And I've quoted, for example, my lords, I'm giving a small instance, my lordship would bear with me for a moment.
Yes.
I've got Land Acquisition Act, I got 4 lakhs. Not taken into account. House, I've built the house on bank loan for 7.5 lakhs, shown 23 lakhs. That has to be deducted, taken into account. As my LIC policy, not taken into account, which they have themselves stated in the FIR, but not taken into the time of final charge sheet. Income, not taken into account. So therefore, all the portions when not taken into account, when deducted from 38, it is minus 6. That is the whole case. If my lordship would only go through my written note of argument, my lordship on the next date, it will be easier for me to satisfy.
I'll fix it.
My lordship would keep it to
Give a copy.
Tomorrow.
What I'll do is I'm giving this copy to him.
No, I'm giving him a copy. I've got a copy.
You give a copy.
Tomorrow.
No,
Not
yeah.
tomorrow.
Not tomorrow.
Day after tomorrow.
We'll see how can we adjust. Let's see the present.
I got a copy of
My anxiety is that a continuance of this particular.
I got an overall idea.
Yes, that is what I wanted to give my lordship.
I got.
Then I'm giving you, not taking. Huh? Really, I'm.
Don't worry,
He was expecting something.
With my lord's permission, item number 72.
My lord?
That my lord had disposed it, directing to renew the prayer after examination of material witness. Actually,
Wrong.
coordinate bench has allowed one of the co-accused bail application.
That also you have a clarity.
Nahi. That is
Wrong.
before Honorable
Wednesday.
Justice A.K.
Better go to that bench.
That bench it is.
That matters would have gone to that. office at least.
I have told my junior, but he is unable to explain to my lord.
Which one?
Item 72.
To go to.
Yeah.
I can't pass that document.
My lord, my humble submission, when is my lordship keeping this matter? Next week?
He will give you a date.
That is, I want it on a Wednesday and at 2 o'clock.
He'll adjust the board and then give.
But
Permission, one line, Lord. Mr. Rai, when was the additional government advocate? I had the opportunity to work.
No, never. He never worked for a day.
And in fact, he used to tell me, the board for what it stands for. And if you are correct on records, don't be scared of any kind of sounds and all this. I'm just reciprocating. I'm just reciprocating.
When you change the side.
My lord, with great respect to my learned friend.
And in fact,
the day he joined me, I tendered my resignation.
And in fact, my learned finance club he was in the Indian Air Force Lords and thereafter joined in. That's when he has his own thing and he installed all kind of things. We learn from all.
We should appreciate the energy level of.
Yes, at this age, my lord, in fact, I appreciate.
This is very important to know.
I'm really, my lords, I'm obsessed with the interim orders. That vigilance case will be stalled, my lords.
Yes, we see that.
Yes. Item number 6 of the hearing list. In fact, I had argued, my learned friend Mr. Rizvi had argued that exhibit 10 your lordship wanted to know.
I don't know. Now,
My lord, the interim order to continue.
Interim order to continue.
Can it be taken up tomorrow, my lord? Because I had substantial argue. I
know that, but what to do? Adjusting it, the board is very difficult.
Hearing.
I'll see that, sir.
Hearing in the.
I'll work it out with him. How can I adjust?
No, it is in the weekly hearing list.
Weekly it will remain. Whenever by 3 o'clock you come tomorrow. If I'm done with all the miscellaneous matter, I'll take up, no problem.
If a lordship permission, that case will take on Wednesday too.
Please enter.
We will adjust and tell.
We will adjust and say. What is the panic? No panic.
No panic, I'm not panic.
But no, item 3, your lordships, maybe continue to next week, your lordship.
3?
Item 3.
Weekly list, let it be. I'm not taking up the matter like whoever is ready, I'll take it up. Otherwise, let it be there. Yes, yes, Mr. Ponda is waiting for us.
No, I was waiting to see what your lordship is making arrangements.
That's the biggest task, you know. If the bench is like this, then it's like that. We'll see any other. Yes, Mr. Ponda, thank you.
It's on the list.
Let it be there in the list. Whoever is ready, I'll take it up.
My lord, my only prayer.
Interim order, I have repaired my key.
92. Who is appearing 92? 92, anybody is there, it has to go to some other bench.
92. Some other
Don't give it.
My lord, it may be treated as parter with great respect because my lordship has heard me in totality. That is the whole case. No, but what I'm trying to say because...
Okay,
No,
then
no.
he- and he- he's
No,
right.
no, it's not that. He stays like that. But I have really submitted my full case. My lordship goes through it, so let it be treated.
I understand, I will hear it.
What I am trying to say is this, suppose tomorrow your lordship's assignment changes. Even if your lordship.
Then let
keeps
it lie
matter,
over.
then it will.
That's one way, that is good.
Yes, so what is the point in making that?
No. I'm partnered. That is the faith and confidence we have on my lordship.